Puff, puff, pass. True crime chat rats. Let's go. Puff, puff, pass. True crime chat rats. All across the world we coming through like that. Taking all the facts, put them in a trap. Cause we coming through like that. When you see the scene, I'm a rat. I be rolling with my rat pack. With my rats chatting about the crimes, the players and the evidence. Where it all went bad. Taking all the facts, and we bring them to the chat rats. True crime social where we be every night, doing everything we do for the truth. With my rats chatting about the crimes, the players and the evidence. Like it all went bad. Taking all the facts, and we bring them to the chat rats. All my people on the internet, all my people from around the world, gonna take you to the place we know best. Cause we're coming through like that. Puff, puff, pass, true crime chat rats. All across the world we coming through like that. Taking all the facts, put them in a trap. Cause we coming through like that. When you see the scene, I'm a rat. I be rolling with my rap pack. With my rats chatting about the crimes, the players and the evidence. Where it all went bad. Taking all the facts, and we bring them to the chat rats. Puff, puff, pass, true crime chat rats. All across the world we coming through like that. Taking all the facts, put them in a trap. Cause we coming through like that.
What's up, Angel? What's up, Angel? Might just be me and you, but I wanted to watch it for a minute on here. Just in case. You know what I mean? So we ain't really doing that much right this second. But we will soon. Just watching the fan. But while we watch the fan, I want to watch the other stuff that happened. Figure out where it's at. All right. I'm watching the fan, so if anything happens, I'll swap us back over. That's your biggest
To you
fan.
now, so please take your seats. So I'm going to read the questions. I'm going to have them marked. Then I will take a short recess, let you all talk about it, and then come back.
Thank you.
So, all right. So I received 3 questions from the jury. The first one is,
Oh, hold on. Somebody's. Might just be me and you, Angel.
Put us back in session and 80 seated.
All right, jurors, I know you want to go home, so it's been a long day for everybody. I have to give you those same cautions. Please do not discuss this case with anyone. Do not do any independent research or investigation into the case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be careful with your social media use. We know you've all been working really hard and we appreciate it. So please just clear your heads. Don't think about this case at all as best you can. And we'll see you tomorrow morning when everybody's fresh to start again. Thank you.
All rise for the court, please. Jurors following.
Well, that was uneventful. For a second there, I thought we were going to catch it.
Decorum?
Okay, Tori. All right, we'll see everybody tomorrow.
Thank you. Court is adjourned.
Dang, 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 dang. Thought we were gonna get lucky. Oh, I sent you the wrong link. Let me send you the correct link. I don't know how it's wrong. Might not have fully copied it or something. Damn. Oh,
I don't know what order they came in, but this is the order I got them. This is the order I'm going to read them. What is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The second are video clips of Karen's interviews evidence. How can we consider them? And the third, does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? So I will give you some time to consult. I think the first one, I'll hear from you as to what
no, Mary B. She just came back and sent the jury to the house. Ridiculous.
the time frame is, and I don't need to hear from you now. That's pretty clear cut what they're looking for. The second one are video clips of Karen's interviews evidence. How can we consider them? Well, we know they are evidence and they can give them whatever weight they want. I would also be inclined to give a humane practice instruction, and tell me if you want the digital evidence instruction. It's a little awkward because it would be something like, before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the person who appeared in the communication was in fact Karen Read. So think about that when I come back out. But I think it's appropriate to give a humane practice instruction, and also tell me what you think about what to say about the weight. The third question is a little bit more, I think, unclear as to exactly what they're looking for. Does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? What I'm proposing, I gave you both a verdict slip where I included the language. I know yesterday I said they have to be read hand in hand, the jury instructions with the verdict slip. I've incorporated the language from the jury instruction into the verdict slip. I've given each side a copy. When I come out, I'd like your input on whether you think this is appropriate. I would instruct them, as I did before, that they start at the top and work their way down. That's the only thing I did not specifically put in here, but I think it takes it step by step.
It looks like it.
I don't know what that is.
I don't know, dude. Let's watch it.
No way.
Yeah, dude. Let's just watch somebody's random live stream.
No way.
You ever
Uh-huh.
you ever just look up StreamYard on YouTube?
No.
Well, sometimes people put the StreamYard link in their description,
And you could just randomly go on people's
and
lives.
you just pop on their stream.
That's crazy. I thought we might get to see some fireworks this afternoon, but they're not even going to work till 4 o'clock.
Yeah, that's pretty gay.
Like, can we do this till 5:30? I know you're tired, but can we get this over with?
Yeah. Yeah, seems like she's just dragging it out. It's pretty disappointing.
I'm trying, man. I see that. but I'm way behind on that. Too.
Oh yeah, that's a nice head. That's an old person's hair. This cameraman is on point.
First day.
Oh shit, Misty.
What?
I
Oh, hey,
said
Miss.
Misty.
So went live. Thought we were gonna freaking catch the verdict. No, we did not. We caught the sending home party. What's up, Yellow?
What? I feel fair. Folks, the same thing. You're not giving a statement. Don't mob them. Let them get this car safe, please. Okay? Thanks, guys. There's not going to be any comments today.
What's up, clerk? MJ?
I think they shut her down or something. Which kind of makes sense. We don't want to have.
Yeah, it's just on live back here.
Yeah.
Damn.
Yep. Well,
Yeah, so I didn't have a whole show planned, but kind of never do. You don't think there's be a copyright issue with those fries, do you?
I do.
Hey, those are my fries.
Hmm.
Nothing else good happened besides that little 3-minute question fiasco.
Yeah. Yeah, that was kind of disappointing.
Yeah, it was very disappointing. So let me find something else for us to watch. So what happened to you yesterday, Dane? Did you fall asleep?
No, no.
Because you were super quiet. What was up with the super quiet?
Give me 1 minute.
I don't see him. Hold on, I'm looking for something. Yeah, I can't just watch their, like Tom and them's lives. I don't see any stations that are live outside of anything. Yeah, play something else. Play something else.
All right, jurors, we're in receipt of your question. We've
Yeah, I
been
can't
working
just
on
restream the Young Jerks.
making sure that the answers we give you are the right ones, so it's taken us a while. So the first question, what is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The answer to that question is that you folks have all the evidence. And remember,
sidebars. They don't get to see all of this stuff that's happening in the news or outside the courthouse. They don't get to see all of the motions for this and that. They're in that jury room and they're in that courtroom when there is case evidence.
And Michael, I just have to ask, now it's off screen, but there was a person in a pink shirt, a big dog in a pink, harness, whatever that was on that dog. And you have to wonder, is that coincidence or is it at all speaking to the fact that there's that whole argument of dog marks on John O'Keefe?
Well, the person probably just has a dog and decided. I don't think it's a coincidence that the dog was in pink. The fact that they were walking a dog by the courthouse, I don't think it has anything to do with Chloe. Yeah, maybe it was Chloe.
Lean in.
I'm trying. It may or may
Just
not.
Stood out to me.
No, and again, that I think really shows, Matt, and you can speak to this, truly the amount of support that Karen Read has in the community. It's really been something Vinny's spoken on it. In cases like this, it's so rare for a defendant to have this kind of support. But yet here in Canton, and I guess because of some of the history, we know a little bit about some of the issues there, that this community really has come out in support of Karen Read.
Well, I think that's...
Finish watching this real quick.
remember, it's only you who decide the facts in this case. All right, that's the answer to that question. You are the fact finders. We're in receipt of your question. We've been working on making sure that the answers we give you are the right ones, so it's taken us a while. So the first question, what is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The answer to that question is that you folks have all the evidence. And remember, it's only you who decide the facts in this case. All right, that's the answer to that question. You are the fact finders. The second question, are video clips of Karen's interviews evidence? How can we consider them? Yes, the videos are evidence. You should weigh the defendant's statements in the videos as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally. So that's the answer to that question. So for the third question, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? So with that, what I'm going to do is I have amended the verdict slip. It's the exact same verdict slip.
Sherry D.
And it's still consistent
what's
with
up?
the jury instructions I gave you.
Hey, Sherry
but
D.
it's a little bit easier for you to follow. And for purposes of going through this, we'll go through it together. And I've got a copy for each one of you, okay? All right, so you'll see it really is the same verdict slip, but we've added a little bit of language to help you follow it through. So the first charge, manslaughter while operating a motor vehicle under the influence of liquor. So first, in the above entitled case, we say the defendant is, 1, not guilty of the offense charged or any lesser included offense. If you find the defendant not guilty of the offense charged or any lesser included offense, stop and sign the verdict slip. Now, then you go on to guilty of the offense of as charged, manslaughter while operating a motor vehicle under the influence of liquor. Check one or both of the following: manslaughter while operating a motor vehicle under the influence of liquor, and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip. That means on each one, when you stop and sign the verdict slip, that means you have a verdict on this indictment. So stop and sign the verdict slip. If you find her not guilty of manslaughter while operating a motor vehicle under the influence of liquor, then continue below to the lesser included offense. And first, under 3 is involuntary manslaughter. If you find the defendant guilty of the lesser included offense of involuntary manslaughter, stop and sign the verdict slip. If you find her not guilty of involuntary manslaughter, then continue to the next page. Guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence. And you have to check one or both of the following: motor vehicle homicide under the influence of liquor, and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below to the guilty of the lesser included offense operating under the influence. And you check one or both of the following: operating a motor vehicle under the influence of liquor, and or operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of operating a motor vehicle under the influence of liquor, then stop. If you find the defendant guilty, you stop and you sign the verdict slip. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1. And remember, your decision must be unanimous. All right, does that make it any clearer, hopefully? All right, so with that, I am going to send you back out.
Before the jurors are set up, can you see-
Sure, why don't you come on over?
Anyways, I usually don't do this, but we'll watch a little LYK and see what he says about the verdict form. Since we ain't got nothing else to do. What's up, Lolene? We'll watch a little bit of it. We might stay live, we might not. Depends on if Mary B and them can. Yeah, there they are. What's up?
Hey, I
Yo.
couldn't get on because I don't get service, dude.
Oh,
Ugh, what a day.
what are y'all doing now?
We just got in the car. Janine's car is somewhere else, so she went there. And I'm with my friends. Gary, who was the most popular guy here today with his DePietro sign. People loved it, including DePietro.
Yeah, according to him, it was.
Nice. Well, I wish I'd have got home earlier so I could have got some walk around video.
This way?
Well, I mean, it's just, I can't get service. I was trying to sign in earlier so that I could get them walking out, but I couldn't get on.
Probably got 100 people down there live, soaking up all the bandwidth.
Yeah, exactly.
Just stop. This is good.
There's like helicopters and shit.
We just went from an hour and a half to 50 minutes.
That's a lot. I was hoping we'd go live right here at the end and catch the verdict.
Yeah, that's what I was hoping that we would see a verdict, but yeah, no. It's because Bev won't just answer freaking questions.
I know.
Is she like my curious is like she can't do that? You know what I mean? Like,
She can do that.
you know, like she's like I can't give any like I can give you instructions. You have all the evidence.
She can't make an instruction on a hypothetical, she said. But like,
You know.
you can, yeah, you know what they're asking.
Yeah.
So, yeah. Here,
Going live tonight, Meredith?
I don't know. I'm live right now, but
I know, but
let me see if I can turn this around, because are we driving by?
Yeah, we're gonna be driving by.
All right, we're going to be driving by, so I don't know how to turn this goddamn thing around. Cam? No, that's not it. More?
Dean.
Yeah, you go to settings and then you go to camera. Yeah.
Got it. Back camera. All right, I'm going to roll down my window. So there's Mike from Justice Served. He's over, see the tent?
Cool.
That's it. That's that. There's so much traffic here. So we had to park far away because the registry of deeds was full.
Well, there'll probably be a verdict early tomorrow.
You think?
Those were some pretty telling questions.
Yeah, but why didn't they just do it today?
I don't know. I think they're trying to figure out what's going to happen if they only find her guilty for driving under the influence.
What happens to people every day?
Which is stupid.
Or if they can't come to a decision to that, but they've voted not guilty on the other charges.
I think that still hangs the whole thing up.
Really?
Yep.
Well, I think that's what Bev was trying to say. Well, no, because I think that she still can. They can still do that. She just couldn't tell them that.
I don't know. That's we were gonna watch a little bit of OYK.
Yeah, go for it. I'll just hang out.
I think I'm echoing somewhere.
You're echoing? Okay, hold on.
I think.
Settings, camera.
Or Dean turned into a robot.
All right, I'll mute myself and just hang out. I'll record outside when there's something to see.
Sweet. Put her up here where everybody can see it. We'll swap it if we got to.
So that's mind-boggling from the jurors' perspective because they went, 27 hours last time? And I think if they go 27 hours again, it would put us into next week, if not very close to going into next week. Will that affect, any Allen charge or anything that the judge does, anything the lawyers want? All very, very interesting. Not today. They are leaving now. That's what I figured, Crystal. Court will be live at 4:20. Okay, we will jump in there then at 4:20. Yeah, no surprise. And I don't think anybody should freak out about the fact that they don't have a verdict today. Okay, that really is no surprise. And what I kind of thought would be a very average and normal, if it wasn't for the first trial, I didn't expect much to get done on Friday. They deliberate most of the day today. Even if they feel like they are close to a verdict, in a lot of the high-profile trials that we have followed, the jurors have wanted to go home and sleep on whatever their verdict is, especially when it's something so serious involving loss of life, something that is somebody that is accused of something this heinous, possible life sentence that we're looking at, which we'll talk about today. So we will go live with court at 4:20 and see what they say. But they come in, they talk about it today. Maybe even if they've come close to a verdict, they want to sleep on and talk about it tomorrow. My So go ahead and throw that poll up before I give my prediction. But while we're waiting for them to get to court, let's take a look at the defense's motion here regarding this verdict slip. And it's an interesting procedure and process because the law doesn't always do the simplest things. Lawyers commonly make things more complicated than they used to be, or than they need to be, I should say. And lawyers are very slow to make changes.
They're working in their best interest, huh, Dean? Always working in the lawyer's best interest. For sure.
Very slow to get up with the times. How long it takes something you propose to change a rule to actually become a rule is frustratingly long, even to the lawyers, and sometimes especially to the lawyers. We've got to debate this back and forth and back and forth, put it up for final reading, edit it one more time. It is so frustrating, and we are so slow to get up with the times. So it shouldn't be a surprise when judges want to stick to the status quo. They don't want to be the one to make the change or the new decision, even though many times that's what's necessary. And that's how we progress in our country. So here we go. Defendant's motion to amend verdict slip. Now comes the defendant, Karen Reed, to request that the court modify its jury verdict slip from its current form. Ms. Reed submits that the proposed amended verdict slip improves clarity for the jury in understanding its tasks and reporting its verdict. The current verdict slip, particularly the slip for count 2, risk confusing the jury and thus causing errors. Respectfully, the present verdict slip is unclear and otherwise confusing. So here's what I'll say about it. It's not incredibly abnormal to some other verdict slips, but when it comes down to a hung jury on different verdicts, that's where it gets really confusing. That's where it creates a situation where maybe there is a not guilty verdict on one of the main counts and a hung jury on one of the lesser includeds, which would prevent the Commonwealth from trying Karen Reed again on one of those higher counts in the future. And that is the situation that we dealt with last trial that the defense is trying to eliminate. This lack of clarity and resultant risk of confusion and error can easily be minimized by tailoring and clarifying the verdict slip to better aid the jury in memorializing its verdict. Indeed, there is no compelling reason not to do so. So I would disagree with the defense here. There is a compelling reason not to do so. The compelling reason is if you're the Commonwealth, you want to argue, we want to try her again. And we want to try her for as serious of a crime as we possibly can. So let's not let the jury check not guilty on any of the other counts in count 2. That's the compelling reason, which is not an appropriate argument. So I don't think we're going to hear anybody make that argument. But that's the only reason I can think of why you wouldn't want to make this change. I guess I should say that reason, and Judge Cannoni doesn't want to upset the apple cart. She doesn't want to do anything new. She wasn't overturned for this decision last time. So why would she change it this time? That's her mindset. Specifically, Ms. Reed proposes that the court use the verdict slip attached as exhibit.
I think y'all are way behind. Something to do with Mary B's connection, I believe. Does it sound better to you, Dean, or am I still echoing?
Yeah, you sound fine.
You would leave me echoing, though.
But hey, we're going to look at that together,
You know,
which presents formatting changes, not substantive changes, to the court's verdict slip. That the jury has started deliberation does not preclude the amendment, affirming verdict slip revision during jury deliberations. I don't think there's anybody on the jury that would be like, oh, wow.
Oh, yeah,
this
no, he's
huge change that we have in the
through
verdict
you.
slip
Yeah,
is
yeah.
going to make me change the way I would vote. I don't think that's going to happen. I don't. Indeed, the court amended the jury verdict slip in Ms. Reed's first trial while the jury was deliberating. A verdict slip is a tool designed to aid the jury, a recognized means of reducing errors in the rendering and announcing of verdicts. It is well established that verdict slips are of no binding legal significance. A verdict slip as a matter of law requires a public announcement in open court. No verdict exists if none was announced. It's like the defense is now citing case law that was bad for them before. Because verdict slips are tools to aid the jury, their primary goal, in addition to ensuring a defendant's rights, should be clarity for the jury in both understanding its charge and reporting its verdict. This case crucially found that the verdict slip only served to confuse the jury. In another case.
So I finally looked at this through the YouTube studio, Dean. How do you stream out of there? You don't have anything.
Okay, so
Backgrounds and all that crap.
you don't really stream out of there. You typically use another like software. Most
Yeah.
people use OBS, but there's also Streamlabs OBS, and that just keeps track of the analytics.
Okay.
You can stream through there, but
Be kind of weak. You just be you.
yeah, but yeah, that's up when you're using like OBS and things like that.
Cool. It just looks weird. Like you would have zero control over anything almost. No banners, no video boxes, media.
Yeah, because you're not really. That's just your live control room to tell you how many people are watching, and things like that. Just the analytics side.
Do a little boots on the ground stuff today. See what happens.
That's a bad mugshot. That's about truth right there.
Absolutely.
Send it to me.
I think that's Gary. I think that's Gary. And
Screenshots.
That's a bad mugshot.
yeah, so that's who's with Mary B.
Yeah, I saw him on a bunch of people's streams. Or the sign. There was like the sign was on Tom's. Sweet Woman posted it being on some other person's stream.
Cool. He looks like the dude I watch all the time on Smoking Scan.
Who?
Thank you for taking the picture.
Smoking Scan. He watches all the police chases and riots and all that stuff. And he smokes the whole time.
Did you get on the news?
I did. Channel 5's going to be on at noon.
I knew it. I knew it.
Channel 5. It's going to be on the news at noon.
All right, I'm gonna go find Marilyn.
I'm not.
Oh, Joe. 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 Right here.
Mary B's not up here to tell us all who this is. But we know that's Nan. Janine and Nan. Janine, Cheryl. Don't know who that is, and Mary B.
Screenshots.
That's a bad mugshot.
Let's see. Uh-oh. Yeah.
Attention for a minute. Why is a verdict? Karen has asked, and I'm just repeating, Dina, and I'm just letting you know, if there's a verdict, Karen has asked silence. Okay?
Well, the
We can go
O'Keeffe's are going to come out first.
Yes,
No
and the
Bailey,
O'Keeffe's
no
are going to come out first. So when the O'Keeffe's come out, we do what we always do, we show respect. But when Karen comes out in those steps,
Oh,
You just be you. Yeah, okay?
Hold on, we gotta go back. There's Connor. He's barely bigger than Mary B, talking smack to me all the time, Dean. Shit. No, that's pretty cool. I bet y'all had a good time.
Connor says that's not him.
Of course he would say that.
Essie, she's awesome.
Cute. Mary B down there just hanging out with all the big shots. I bet y'all had a good time. Did it rain the entire time y'all were out there, or did it start at the end?
At the end, it rained because sweet woman, while she was driving there, was like, "Oh, great! It just started raining."
Dang it! I saw where she told somebody she had just gotten there, and Bev was like, "Okay, everybody go home."
Yeah,
that sucks. It's like going live, and then 5 minutes later, Bev's like, "Okay, I know everybody's tired. Let's go home." Fuck that! Y'all haven't worked a full day yet. They have not worked till 5 o'clock one time, and she was so worried about getting this trial over with. We can't work an extra hour. Whatever. Can't go an extra hour, 2 or 3 days off a week. Oh, man, you guys must be tired. You ain't done anything.
Clip has the real potential to confuse the jury and cause errors, particularly with respect to count 2. Manslaughter while operating a motor vehicle under the influence of liquor and its lesser included charges. The form does not explain the process the jury should follow while completing it, although the court instructed the jury that the form should be completed from top down. From the form itself does not provide instructions to stop after the jury has selected a given box. And that's why I thought it was important for us to go back and listen to exactly how Judge Cannoni explained this to them. I'm going to read some comments here because people are having some fun. PETA, thank you for giving me and the chat, a better understanding of our legal system. Thank you, Leslie. Chris K. Peter, I was disappointed to find out that you are only a civil lawyer. Is there anything else you haven't told us? Is that, in fact, your real hair? So Chris is joking, probably based on some of the stuff that, yes, this is my real hair, by the way. Basically on some of the stuff that's going on in Twitter. It's just really hilarious. People are posting my website as if I didn't write the stuff on my website. And as if I don't say every single time I'm a personal injury and wrongful death lawyer. That's what I do 99.
But he was trying to get Connor and Janine hooked up last night, Dean, while you were asleep.
Wait, what?
Yeah. In the chat.
Nice.
But yeah, you never said why you were so quiet yesterday.
I just had things I was doing.
Crocheting?
What's up?
Did you finish crocheting your blankie?
Yeah.
Sweet. With the tears of your enemies?
So
9%
wet
of
ass
my practice
blanket.
is that.
Plankton? What?
I said that's a wet ass blanket.
A little moist on one end.
1% is criminal law. They act like, oh, why should he ever comment on criminal cases, even though I've prosecuted criminal cases, defended criminal cases in state and federal court, tried many criminal cases, grew up working in my dad's firm. Well, all he did was criminal cases, was a law clerk, legal assistant, and did paralegal work on all sorts of criminal cases. But yes, Chris was joking because it's really funny, the people that are on the internet and how they think they're taking shots.
Oh, Gingy's thinking it's a Mary B and Connor connection.
Ooh.
Oh, Connor. Sly dog. Bird dog.
It's funny. How'd you and Papa Tragos hit him on Friday? Just checked and didn't see a score posted on Gin. Oh, that's a good point. I should post my score on Gin. Here's the problem. My dad always takes the cart at the end to go like into the clubhouse for us to eat, and I walk my clubs to my car to drop them off before we eat, and then we always lose the scorecard. I think I shot right around 81, something like that. My dad hit him pretty good. It was a little higher score, but he hit him pretty good. No complaints there. I pray for Karen that they make an amazing movie out of this and give her half the proceeds so she can live a beautiful rest of her life. I think Chris had to come. Yeah, here we go. Peter saved me. My sarcasm fell flat. For the record, if I needed an attorney for PI or criminal, Peter is my first call. Thank you, Chris. Yeah, he told me he was going to mess with me on this. So all good fun. I welcome it. I welcome the sarcasm, especially from people like Chris, who are always here, who are awesome, really uplifting in the comments and the DMs. I love you all that reach out. I appreciate you all. I can't obviously respond to every single one the same way, but they are seen. I love it. I appreciate you guys. Everybody that's here to hang out, talk about these cases, and that comes and chooses to do it here. There's tons of places you can do it. I appreciate it. Kathy said, Peter, I can't stand reading the comments about you on X. It is what it is, right? That's what Twitter has just kind of become. I still am going to post on there, still going to try to talk about this stuff. Hopefully people can learn from it. I can learn from a lot of your comments. The mute button is a beautiful thing. Let people scream off into the abyss. But it doesn't matter, right? In the grand scheme of things, I know who I am. I know why I do what I do, and I love it. And I appreciate all of you guys that come out and are very loud in support. You guys are the best. It does not go unnoticed. All right, let's get back to this motion that Ashley, speaking of shout outs, sent to me, and I appreciate it. She sends me all that stuff. The form does not explain the process the jury should follow while completing it, although in court instructed okay. We already read that. Moreover, the form presents the jury with only a single not guilty option applicable to count 2 in its entirety, juxtaposed with 4 guilty options, 1 for each charge. This imbalanced presentation
For some reason, the lawyer you know's piercing voice comes through my microphone, I think.
Yeah, it does a little bit.
That's weird. Nobody else usually does. There's Mary B and Tommy. Boots on the ground, Tom. I bet they're everybody. You got to be expecting a verdict in the morning at some point.
Yeah, for sure.
It's got to be coming in the morning, which means I'm going to be at work, and it's not going to be a difficult. It's another easy day tomorrow, but I ain't going to say I hope I make it home in time because I don't want them to be waiting on me. You know, Dean.
Everything waits on you, Danny.
I don't want Judge Canone to be, okay, guys, go back in there till he gets home from work.
visually favors the guilty options and risks creating bias towards a guilty verdict in degradation of Ms. Reed's rights, in addition to creating the risks of confusion and errors. In furtherance of the salutatory goals of maximizing clarity and avoiding error, Ms. Reed proposes the verdict slip attached as Exhibit A. The proposed verdict slip has several benefits. First, the form includes clear step-by-step instructions explaining to the jury whether they should stop or continue based on their findings for a given charge. Although Massachusetts law does not dictate how or in what order a jury must deliberate, the jury must return a verdict of the highest crime that has been proven beyond a reasonable doubt. The proposed verdict slip's clear instructions aid the jury in complying with that mandate. Additionally, the proposed verdict slip makes clear the jury's choice between guilty or not guilty for each separate charge. Why wouldn't we want that? Instead of presenting only a single not guilty option encompassing each and every charge that is part of count 2. This balanced presentation gives equal weight to both possible outcomes for each charge and avoids any implicit bias towards a guilty verdict, providing the jury with a clear choice between guilty or not guilty for each charge while following step-by-step instructions also minimizes the risk of confusion to the jury. It is beyond cavil that the proposed verdict slip is clearer than the current jury verdict slip. Ms. Reed respectfully requests this court now substitute the attached verdict slip for the court's existing verdict slip in use. Okay, before we get to the verdict slip, I'm going to answer a few more questions. Some guy at work in Boston, whole office is waiting for the verdict. Gorgeous day here in Massachusetts. Surprised the jurors don't want to get outside. Well, they're taking their job very seriously, as they should. And I think that's something we should be able to respect and appreciate about them, and something that should be celebrated. Judge Canone started the jury instructions with, if there's a difference between what I say and what's written, go off what I say. Is that standard? Usually it is, because that's what's going to be on the record. That's what the lawyers are listening to. It doesn't mean you don't want to correct what's written and sent back there with them. I listened to her instructions again. I heard this as well. if the jury is confused on how to mark the verdict slip to achieve a specific outcome, can't they just ask the judge? So they can say, hey, we're confused. What are we supposed to do with this? Judge, we're really confused on count 2. We want to check not guilty on 1, but we don't know how to move on. She also says, kind of at the bottom of the page, you're supposed to be done and sign it. We'll listen to that as well. That I think could be confusing. I saw no issue with the slips, but agree there's no reason not to adjust. And that's kind of the point. Why not pick the best option? Because I would agree, I don't think she's going to get overturned on this decision. In my opinion, any issue might be definition of lesser included.
Mary B, did you happen to record Gary and Hardman getting into it? Hardman, I mean, getting into it? If you did, send us that video.
Not the form. If a juror, a timeline with objective data, cell phone text, voicemails, videos, or car data, I lean count 2. Chloe, I bid him. Peter, if the jury is hung again, who do you think will try her a third time? I have no earthly idea. Peter, do you think the makeup of the jury...
I mean, if you know that the jury's not guilty on everything but a DUI, why would you try her again? That's 2 times now that you can't prove her guilty on the murder and the leaving him there to die. Waste another $3 or $4 million. That wouldn't make any sense. About as much sense as this one.
leaning more female will help or hurt Karen or have no effect. Love from the Panhandle. I would assume female would help. Generally, you want to identify me through my work shifts. Haha, not guilty. And I have a feeling Emily D. Baker feels the same way. John, how about JJ Spawn's putt? I bet him after day 1, hit, and then sprinkled a little bit on him to win. I did not expect him to win. He pulled it off. What a tough tournament that was. Cool that it happened over dinner time on Dad's Day. I agree. That was awesome. Azam, hit the like button and subscribe if you haven't already. Let's get Peter to 510 on this live. That would be awesome. Everybody hit that subscribe button. Okay, I am now going to pull up the defense proposed verdict slip here so we can look through it. All right, so this is Exhibit A to that motion, and we're going to start with count 1. It is a very simple box that says, in the above title case, we, the jury, say the defendant is, the type is the crime charged, the crime is M in the 2nd degree. Then you have 2 boxes, not guilty or guilty. And this is the unanimous decision of the all 12 members. 4-person signs the bottom and dates it. Very simple, no issue, not a big difference from the one that the jury has, which we're going to take a look at that as well to compare and contrast here in a second. Also, it's past 4:20. So let me check the court feed and see if they're back in court. They are not, at least from what I'm seeing on Court TV stream. You guys can let me know if they are. My guess is they're just going to send the jury home for the day, but we will watch it together if it is. Wait, Peter, aren't you going to go to the live? So there's nothing. They're not showing court right now. If they show court, we will go there. Don't worry. But I am 99% sure they are just going to send them home for the day. We will watch it together if it is streamed. Okay, they just came back. Everybody's saying, is that on Court TV? All right, let me pop that in. All right. So this is live. Court's in session. Okay, law and crime. All right, let me go to law and crime. All right, we got it. We're up. All right, here is the Law and Crimes feed, and we are back in the courtroom here.
Back in session, you may be seated.
All right, jurors, we appreciate how hard you've worked today. It's been a long day. I'm going to send you home. So I do have to give you those cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Be careful with your social media use. And I think what's a good idea to do is when you leave here, just leave the case here. Literally, figuratively, just clear your heads. Beautiful day, get some fresh air, and we'll see you tomorrow. Thank you.
All rise for the pledge, please. Jury's called me.
Somebody said, what happens right after this watch? So I'll take the bait. We'll watch for a little bit longer. Are jumping back into the verdict slip here. And we read count one. That was kind of the simple one. Now we are going to get to count two. Count two is the, and I've got, so if somebody said that Vinny is trying to talk to Karen Reed, if he does, let me know. We can watch that together too. When she walks out. Okay, so count two. Here we go. Crime charge: manslaughter while operating a motor vehicle under the influence of liquor. If guilty, check one or both. Manslaughter while operating a motor vehicle under the influence of liquor. Manslaughter while operating a motor vehicle with blood alcohol level 0.08. The reason these two are here is which way did they prove that she was driving drunk, basically? Was she under the influence or was she above a 0.08? Then they have a not guilty box and a guilty box. If you find the defendant of the crime above, guilty of the crime above, stop. It's over. If not guilty, continue.
Yay, Charlie. I'm glad you found us. I don't know. I don't know why you couldn't find me. Because we're too new. We're just a little baby. We were an infant before, but now we're just a little baby. But we're glad you found us. There's your unnamed, unassigned rat suit. Charlie needs a rat suit. Charlie, are you in the Discord? If you're not in the if you're in the Discord, I think you're in OBs, aren't you? If not, you need to get in ours. I'll send you the link in a minute.
Below. And this to me goes top down, like Judge Cannoni tells the jurors to go in the jury instructions, which we're going to listen to here in a second. Involuntary manslaughter, guilty, not guilty. Motor vehicle homicide, felony OUI, and negligence, guilty or not guilty, guilty. Same thing. If you find guilty of the crime above, stop. If not, continue. If not guilty, continue. So we know they only continue if it's not guilty. Then we go to operating under the influence. Same thing. Not guilty and guilty. Very simple. A chart. I love a good chart. Then count three. Simple. Leaving the scene of the accident resulting in death. Not guilty or guilty. So the real part where this comes into play is if they found, let's say, not guilty on this, and they're hung on involuntary manslaughter. Well, next time they cannot, if they, obviously not guilty here, and they get to here, and they're hung, and they're not guilty here, right? They cannot try her again for leaving the scene of the accident resulting in death. They cannot try her again for second degree, and they cannot try her again for manslaughter while operating a motor vehicle under the influence of alcohol. That's really where it comes down to. If there's a hung jury. If it's not guilty across the board, this isn't going to be an issue. If it's guilty of count one, this is not going to be an issue. If it's guilty of if it's guilty of any of them, it's not going to be a major issue, except for the fact that they may have said, we didn't see a not guilty option for the lesser included, which let's now take a look and just kind of compare and contrast the verdict form they actually have. So here's count one, not guilty, guilty. Count two, not guilty of the offense or any lesser included. Some would say objection, compound question, right? Objection, compound question. But then you have guilty of the offense as charged, manslaughter while operating motor vehicle, guilty of the lesser included, involuntary manslaughter, guilty of lesser included, motor vehicle homicide, guilty of lesser included offense, operating under the influence. Much more confusing, because sometimes it can feel like if you think it's not guilty, then you still feel like this looks like every other one, right? 1 and 2, 1 and 2, 1 and 2. So if I think she's not guilty of this manslaughter, am I then going to go down and look at these three? What do I do with these three? Now, it very clearly says, or any lesser included, which I understand. I just don't know why we wouldn't want it to be clearer. I think that this is going to pass muster on appeal. I do not think they're going to win for this appellate issue. And it's kind of cheating because we know they already didn't win on this, but not guilty of the offense charge or any lesser included is probably good enough, but it's not the best answer. And in law school, with so many of the tests we take and exams and even the LSAT, it's not always the right answer because there can be multiple right answers. You're supposed to pick the best answer. And so to me, I agree that the defense's option is the best answer, but I do not think this is a situation where it's going to be something that's overturned on appeal. At least that's the way I see it, personally. Okay, so now let's get to, we kind of already know the answer to this, but I thought it would be interesting to...
So I was trying to find that where Vinny was down there and everything went nuts, but I don't think I found it. I found some footage from down there. That link doesn't work? Oh God, hold on. Dean, are you back?
Yeah, sorry, I'm just eating fried rice.
Ooh, nice.
Hell yeah.
Can you drop the Discord link for Charlie?
Yeah, no problem.
Thank you, bud. Thank you, bro.
Instruction.
The only thing I would respectfully ask the court to include in that sentence is give them whatever weight, if any, you deem appropriate.
All right.
If any.
Okay.
Thank you. Otherwise, it's fine.
Okay. What's the Commonwealth's position?
We have a different perspective on that.
Okay.
The first part of the question, are the video clips of Karen's interviews evidence? The answer should be yes.
Okay.
How can we consider them? I think it's fair to say you should weigh the defendant's statements as you would evidence. Since they've been interviewed substantively, they are like any other piece of evidence. There's no difference, and there shouldn't be any reflection of a difference in the answer. We didn't introduce any evidence in this case and say you should give it any weight, if any at all. We didn't provide a limiting instruction in any way, and these shouldn't be so limited. This is just like a photograph. It's no different than a physical piece of evidence. And so I think the answer should simply be yes. You should weigh the defendant's statements as you would any other piece of evidence. I do not think the court should give humane practice or digital evidence and suggest that some deterioration or further analysis that is different. Those instructions were already given during the charge. In addition, those instructions are in their hand in the written jury instructions. And so, to put it most simply, as I think that we should, is this is a piece of evidence, and you weigh it like you would any other piece of evidence, whatever they decide.
All right. I think I found it.
I didn't know that. When was it? Oh my God. I'm like, anyways, so my friend, yeah, so the other two eyes and the dog. I don't understand that when it says Microsoft, like he's the only one
And she even put a handicap placard on her dash.
You know what it is? Karen, because you know she got railroaded. But at the end of the day, I'm no one will actually. Nobody will ever know. But those people that did it will meet their man when it's time.
Charlie, we have no idea. It's some kind of spam. We don't know what it is. That's just what they said. Could have been a bunch of AKR people reporting the page too.
Oh yeah.
And then and I just tried to get the numbers. I tried to freeze game and yeah, Aiden saw me like that's something awesome. You know how he feels about him. You know what I mean? Yeah. Yep. I didn't do it. Mr. Hardman. I didn't do it.
Here we go.
I got you.
For lunch now, well,
Personally, I think Spacey Stacy got an awesome rat. That rat is killer.
Yeah, I think it's the best one.
That's pretty cool. I like it.
Yeah, and I'm doing
Oh, there's a Jay in there.
I don't know what excuse me. Go ahead. Oh, I was having, I need to see you. Yeah. From a
What's that?
What happened? 1:30. Yeah, the jury had. Yeah. You guys going? Hopefully we have an answer. Yes. Questioning what the time.
Rita come through there like a wrecking ball. Loud. Just bringing that energy.
So my guess is if they think that she was like OUI charge at 5 o'clock, there's no way they can prove that she didn't take more I think that yes, I was actually looking for her. Joyce? She was on that corner and then she left, so I don't know. She has the same hat on as me.
You guys have how are you saying?
I used to feel like old.
Rita, somebody wants you. I'm gonna get Yes. Oh, my friend. Yeah. Thanks, Hopper.
There's way less people on the steps today.
Yes. Hi, Rita. You got a flag. Got a flag.
All right, let's see what a couple of these news stations says about it. Let's unmute it.
Let's listen in.
Can't agree on one charge. Is it a hung jury on all three charges or just one charge? I got some input from the defense at sidebar, essentially saying if we could just ignore it. We can't ignore it. To me, it's a theoretical question, and we don't answer theoretical questions. I tell the jurors that they're not to be concerned with the consequences of their verdict, and that's exactly what they're doing here. So I would propose just writing simply, this is not a question I can answer on this, and sending it back.
The defense position is not, certainly not the question for it. I agree, we can't ignore your question. However, I think that it is apropos, given the timing of when that question came in, literally before the court had answered the other three note card questions. I think that it would be appropriate to send a quick note just asking them, given the fact that there's some clarity in your other questions, does this answer your question? In other words, can you proceed without any further input by the court regarding that second question?
So that made sense initially, but why ask them, do I really need to answer it, to then tell them I'm not answering it?
Because I think at some point, they need to know what the law is. It's a reporting question. In other words, I don't see it as theoretical, as the court indicated. I see it a little bit differently, which is what are our options? And the options are built in the law, not in theory. If they come back with a verdict on more than one count, but they're hung on a separate count, they are to report those two counts, whatever counts they came to a verdict on.
So that's for a later time, right? So this is at this point.
Right.
It's premature, it's hypothetical, it's theoretical. I understand your point. I think I disagree with you at this point. It may be something later. The way the question's worded, if I find this, if we do this. I'll hear from the Commonwealth.
We agree it's consequence related. Your first suggestion, I think, is most appropriate, and we would endorse that.
Yeah, I'm going to do that at this time, Mr. Jackson. I'm not going to have a back and forth with them. I'm simply going to say, because it's true, it's the law, that this is not a question I can answer.
But I would strongly suggest that we find some other way. If that question continues to remain, then they're not going to ask that question. I don't think the court can say, or should say.
What's up, Petty? Dean was just asking about you. Yeah.
I wasn't even here. I literally just got back. That's what you sound like.
Hey, Petty. Petty P.
I can't answer the question because the court can answer that question. The court absolutely can answer it. I would simply say this question is not before the court without further information or something like that. Not the court can't answer that question, because if that question remains in their minds, we're going to end up in the exact same position that we were in last year.
There are other steps that can be taken to perhaps prevent that.
Whatever those steps are, I think the first step down the wrong path is to say,
Ooh, y'all look who's here. It's Tombstonies. What's up, Tombstones?
Yo.
Yo, 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 yo.
Pretty sure Tombstone is a cat.
Yeah. But she does have a rat, though. She got a good one, too.
throw our hands up and say, well, we can't answer that question. Well, we know we can answer.
So I don't know if I want to put you in an uncomfortable position, Ms. Giannetti. I'm inclined to answer the question the way I stated.
Do we have 2 minutes to confer with counsel, John?
How about 1 minute? You guys are 10 minutes late.
We do it 1 minute. Thank you.
There she goes.
All right, you are listening here to, well, as we watch a brief sidebar among the attorneys there for Karen Read. The question that's come in concerns if the jury is unable to reach a unanimous decision. Essentially, defense here very clearly saying, no, hold on.
I got good at talking. We talk for 10
Did not
minutes.
answer the question at this time. I would simply ask that the court answer the question as you suggested just now in open court. It's premature to address this question at this time.
No. What do you say, Mr. Brennan? My response was, this is not a question I can answer for the reasons I stated. It's theoretical, and we tell jurors that they cannot be concerned with the consequences of their verdict. And that's exactly what you would be asking me to endorse. What's the Commonwealth's position on the proposed?
I agree with your first suggestion.
Yeah, I'm going to send it in like this. Your objection's noted.
Your Honor, if I could make my record a little bit clearer, the court's indicating that it doesn't answer questions about the consequences of the juror's verdict. That would be punishment. Of course, you can't answer a question like that. This is not the consequences of the verdict. It's how do they report a verdict. So I think saying I can't answer this is sending a false message to the jury. If the court would simply indicate this is not appropriate for me to address at this time, that assuages all concerns. Certainly assuages our concerns and it protects Ms. Reed's rights. I think that
Well, I think what I could add is this is a theoretical question, not a question I can answer. That does the same thing. Is there an objection? I understand, Mr. Jackson.
add the clause at this time.
Is there an objection to me putting this is a theoretical question, not a question I can answer?
No objection.
I wouldn't allow the court to finish writing, but at this point, that is over our objection. I
understand.
I just want to make sure the record is absolutely clear. That's over our objection. I don't think that's an appropriate answer to a very, very clear question that could be answered in an innocuous way that does not affect Ms. Reed's rights. I
Okay.
think this way it does.
Okay, it was a clear question that the defense first told me to ignore. So
I didn't
is
say
that.
that. Your Honor.
All right, we are all set. So let's send this in.
Damn.
All right.
Oh my gosh, she is so aggravating.
All right, you are listening.
Oh God. Just cut him off right in the middle of a fucking sentence.
Yeah.
You just don't see these other judges doing all that. I mean, they're staring and shit, but just cutting people off right in the middle of a sentence when they're trying to tell you you're doing something that violates their client's rights. So we'll see if we catch anybody good in these walk-arounds. Okay, loud. Yeah, they're doing there. I hope it may be sends me some more boots on the ground too. I guess they're not hanging out. Everybody ain't home.
Nice cameraman. When are you gonna have LA Pinto on again? Cheddar Crispy. But you have to, don't you? Because so.
Hey, did you explain the case to Wilma? So he's got people just all over him trying to get pictures.
Yeah.
Cool.
That's the next.
No, I'm doing it backwards. You're good.
Yeah, Sophia. By right, she's already done it. She said, no license. Yes, you drive. I know. I know. She wants all the things. That's
Maybe you should bring
All right, let's hang out with Erica Walsh for a minute from this morning.
Shout out to my girl Jen who got me into
There's Cheryl with an S.
You want to say a shout out to anybody?
Today's the day.
Good morning.
I don't know if you work with the guy.
Oh, I don't know who's got the camera. There's Erica. She's finna get the camera.
I heard two guys tell yesterday. It's like good. I hope they bring it here.
You want to go on, Erica? Talk to people? With the Irish flu?
What do you say? What do you say? Going where?
That I don't know. They get a big paddy wagon. That's with the two of them. Yeah, we're going in one.
Hi, guys.
Just now?
Can you guys hear me?
Yeah.
We had to tape up the back of the phone.
Why?
It said framed on it.
Oh, Jesus. I can't do it. I can't do it. I can't.
Just kidding.
Hang in there, kid. Sidewalk open.
Hi, Mike. Hi, Scott. Riviera. What? Hi, Jilly. I am being good. I'm always good. Hi, Leanne. Love you, boo. Yeah, that's Rogie. He'll probably be here today. He said he was. He calls me Sasquatch, even though I didn't even fucking do anything. Whatever.
Sasquatch.
Yeah, Rogie. He was over. Yeah.
On the bicycle,
So listen, he's sitting over there on a bench, right? And he's on live talking about how he found a beautiful secluded area. He can see everything. Nobody's bothering him. But the juror bus is literally on the live. So we're all like, someone come up to me and told me.
All right, we got an all updated Chat Rat song. This is a lot of updates. This has been a lot
Yeah,
of
it's
updates.
every time.
People.
I think Charlie just asked for one.
Charlie got one.
Nice.
So while Tombstones is here, these are your final rats.
From coast to coast, we on that grind. True crime tales, we follow the signs. Chat rats rolling always on time. We dive in deep into every case, from alibis to that suspect's face. Gobble drops and the stakes get high. We light it up, truth never dies. Global crew, all eyes on the stream. Investigations run like a dream. Popping facts with that midnight spark. Solving crimes even in the dark. We got theories and we got files. We got timelines stretching miles. Clicking links, checking the stats. Say it loud. We the Chat Rats. Let the story unfold from the first 911 to the courtroom code. Running down leads, we don't relax. Light it up, we got the files. Puff pass, bring the justice through. From the crime scene sketch to the interview. Together we vibe in every chat. Watch us work, we the Chat Rats. Murder boards and old police logs. Late night lives and digital fog. We question the lies, breaking it down. Flashlight minds in a sleepy town. Whispers turn to witness names. Motive, weapon, unravel the games. With every puff, a clue gets clear. Truth hits harder than smoke in the air. Follow the thread where it led. One more clue, what they said. Puff, puff, pass, let the story unfold. From the first 911 to the courtroom code. Running down leads, we don't relax. Light it up, we got the facts. Puff, pass, bring the justice through. From the crime scene sketch to the interview. Together we vibe in every chat. Watch us work, we the Chat Rats. Light it, pass it, the journey goes on. From the crime to the court, dusk till dawn. Truth seekers under.
That's Terminator Rat.
Okay, could I just make one comment?
Yes. What?
They're all super great. Carrie B looks like a Care Bear.
Yes, that's the point.
Okay.
Yeah. Her profile pic's always been Blue Care Bear.
Oh, has it?
Yeah. So she the Blue Care Bear.
Digital hats, solving mysteries. We the Chat Rats. The journey goes on from the.
Look at the cheese, dude.
That's good.
The cheese's cigarette moves up and down in his mouth.
The journey goes on from the.
Little animated cheese. Crazy eyed cheese. That's hilarious.
About the video. So I like look and I'm like, oh, where is he? We're trying to think like,
Oops. I just screwed that up, didn't I?
Oops.
All right, so we'll see everybody at 1:30.
So they're coming back at 1:30.
Yeah, thanks. Yeah, I hear ya. Hey guys. Hi Canada. Hi Sally Ann.
I got too excited
Ontario.
about
Hi
the
Ontario's
cheese
watching.
and clicked the wrong thing.
Yes. Hi. Good morning. Yep. Yes. Good morning. Yep. We got a few countries in here today. Wow, it's amazing. So you see this right now, in about a half hour, it'll be a lot different. Tina's dying laughing. I love seeing it.
No, because the people that live in Dedham know we're all down here.
Yeah.
There's no, but they insist on walking the dog through the whole
Yeah,
crowd.
yeah. They could go anywhere
Dennis
else.
just yells, bring your cats next time, bring your birds too, bring all the fucking animals. You think they'd avoid it, fully knowing well people are down
And they can
here.
go down any other street. I know. Yeah. We've only been here every day. You know what I mean?
Bring your cats, bring your birds, bring your chinchillas.
Listen, please do. Please
bring
do.
Your fish.
I want to see them.
Bowl in a fucking wagon and bring it down.
Oh yeah, bring a fish bowl. But that's not the one I want. I love it. My cheeks hurt.
Sorry, I got to listen to this one more time. It's 10 minutes. I just want to hear these questions one more
So please take your seats. So I'm going to read the questions. I'm going to have them marked. Then I will take a short recess, let you all talk about it, and then come back.
Thank you.
So,
Dan, did you see the pictures of Connor? Were you here?
Yeah.
Oh, yeah, you were here. I forgot. You're always here.
all right. So I received 3 questions from the jury. The first one is, they appeared on note cards, so that I don't know what order they came in, but this is the order I got them. This is the order I'm going to read them. What is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The second, are video clips of Karen's interviews evidence? How can we consider them? And the third, does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? So I will give you some time to consult. I think the first one, I'll hear from you as to what the time frame is, and I don't need to hear from you now. That's pretty clear cut what they're looking for. The second one are video clips of Karen's interviews evidence. How can we consider them? Well, we know they are evidence and they can give them whatever weight they want. I would also be inclined to give a humane practice instruction, and tell me if you want the digital evidence instruction. It's a little awkward because it would be something like, before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the person who appeared in the communication was in fact Karen Read. So think about that when I come back out. But I think it's appropriate to give a humane practice instruction, and also tell me what you think about what to say about the weight. The third question is a little bit more, I think, unclear as to exactly what they're looking for. Does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? What I'm proposing, I gave you both a verdict slip where I included the language. I know yesterday I said they have to be read hand in hand, the jury instructions with the verdict slip. I've incorporated the language from the jury instruction into the verdict slip. I've given each side a copy. When I come out, I'd like your input on whether you think this is appropriate. I would instruct them, as I did before, that they start at the top and work their way down. That's the only thing I did not specifically put in here, but I think it takes it step by step, an analysis to do it. So how much time does the defense want to be able to respond to me?
Perhaps 15 minutes.
Okay. And the Commonwealth?
That will suffice.
Okay. So it's 7 past. Why don't I come out at 25 after, give you 20 minutes?
Thank you, Your Honor.
Okay.
Let's watch this one little video on whatever they did with Koberger in the last couple of days, and I'll find something.
Brian Koberger prepares to return to court for a hearing that will determine. That's where jurors would consider sentencing Koberger to death or life in prison if he's found. Koberger was arrested more than 6 weeks after the murders at his parents' home in Pennsylvania, and a lawyer representing him at the time said that Koberger told him that he was eager to be exonerated. Now, the trial is scheduled to begin in August in Ada County, Idaho. That's where Boise.
Too much rundown. Let's see what
Talking
Vinny
about OUI, Ted. They're not talking about murder. They're not talking about manslaughter. They're not talking about involuntary manslaughter. They're talking about what is the impact of finding her guilty of OUI. And I think the confusion probably is on that second page of the verdict slip where there's just one not guilty. And I think they're a little confused as to how that relates to all the charges until you get to number 5. But if I am on the defense team right now, probably a little optimistic at this point. If I'm a prosecutor, which I was, I'm not feeling good about this question at all. Now, I can be totally off. Sometimes a question is just from one juror. It's not from all 12. There might be confusion from one juror. But though I'm reading these together, Ted, they are connected. What's the common denominator here? OUI. Was she driving under the influence at 5:07 or was she driving at 12:45? What did Alan Jackson say in his closing argument? We don't know what she did between 12:45 and 5:07. We don't know when the alcohol was consumed. We know when the blood was drawn. We know when the test was done. It seems to me they want to know if it's about 12:45, we might have reasonable doubt. If it's about 5:07, okay, maybe she drank afterwards.
How does the video question?
I have no other
enter
way to
in?
read this, Ted.
Yeah.
Do you have another way to read this, Ted?
I think you're spot on. The confusion over the verdict form is something the defense was concerned about before they went back to deliberate, and Judge Cannoni was insistent on keeping what they had drafted. What about question 2? Are the videos evidence, and how do we consider them? If your gut is correct that it's all about alcohol, she did talk about consuming drinks in the video evidence.
And that was one of the, and that was one of the things we talked about early on, right? There was a whole series of videos that they played early on in the case where it's her talking about how much did she drink. That would be an admission, a confession to drinking. So again, I think all these.
Laura, we are irritated like the twins in the Matrix. We are becoming irritated.
Danny's on his period.
What?
What?
I'm on my what?
On your what?
Dummy say what? Almost got you.
Almost.
Got one. Almost got you.
But you didn't.
We're pretty close to our 3-hour mark now. We really did not have anything to do. I just wanted to catch the verdict, but here we are.
Dude, that sucks, Connor.
Cranberry juice for my period. You got stung right this morning? That sucks.
Yeah,
Happened
that
to me
fucking-
a few weeks ago. As soon as I got out of the damn work van, bam! Like, ow. Red wasp. Yes, Laura. She vanished.
No, nothing happened. Danny was just like, you know what? Fuck that channel.
You know what? Fuck this momentum. We don't need this fucking momentum. Damn, we were over halfway to being super chat.
Yeah,
We'll
he decided to give up on that one.
It's too easy.
Yeah.
We come back to this one, do a lot more shitty content, get a lot more views. We're not
Fuck
playing
yeah.
this time. Well, we kind of are playing this time too, but we're seriously playing. Play for keeps, like cocaine and waffles.
We go together like cocaine and waffles.
Yeah, if you're not first, you're last. And if you think you're gonna get in first, then you just quit. Cancel your shit. Delete it all. Start over. It's too easy.
Shake and bake.
Shake and bake. Shake and bake.
These things are potentially connected. Now, obviously, the prosecutor says there's a lot more to those clips that he played for this jury, but the other two questions are not connected to that. If you want to look for the common denominator in all three questions, it's drinking.
Petty. They do not want to have a contest. Okay? Against me and Dean. They don't want to go down that road. That would be embarrassing.
And driving. It's not murder.
Yeah,
I don't know how else to read this. Now, again, everyone needs to know, I know, we've covered these before. Sometimes questions come from one or two jurors that might be in the minority that are asking these questions. And the others want to say, okay, we'll ask the questions and then you've got to come along with us. But
Absolutely.
if this is the jury speaking as a whole, this is enormously good news. I would be much more optimistic if I was on the defense side, which I never was. But as a prosecutor, I would not feel good about these questions at all. They're talking about OUI. They've gotten all the way down to the bottom charge of count 2, Ted. We're not debating manslaughter, involuntary manslaughter. The first jury, that's where the first jury was. They were debating involuntary manslaughter.
Yeah,
They've gotten below that.
If they have found her guilty of murder, they don't.
Dean, for a second, I thought that was you trying to talk. And I went to mute it. And I realized the whole time it was that guy. Vinny would shut up and let him talk. It's your guy, Vinny. I was like, damn it, Dean.
Yeah, my bad, bro.
I was like, damn, Dean, shut up.
I just can't help myself.
At least you're not breathing into the mic like you used to.
Fuck you.
Don't care about the OUI. They would just.
It's irrelevant.
Yeah, and they would
Okay,
find her guilty of
yeah.
that just because. So that's a great point.
Let me tell you something else, Ted.
Yeah.
Can I throw something else in for
yeah,
the folks
absolutely.
watching at home?
Yeah.
You ask a question like this, once you get the answer, a verdict could follow very, very quickly after the answer. Now, we know there's going to be at least 15 or 20 minutes here. And what we've also seen in the history of court TV, Ted, is sometimes when they take too long to answer the question, the jury sends out another note and says, we have a verdict. So I'm not leaving this spot. Let me show you what's happening right here. This is a moment of anticipation. It's palpable, what folks are feeling out here right now, because everyone, as these questions are being asked and answered in court, everybody's streaming it, so they're hearing it as you're reporting it, Ted. So at this point, I think everyone here is anticipating that something big is going to happen very, very soon. Earlier this morning, the crowd was thinning, much thinner than yesterday. Since this note came out, it's starting to fill up again. As a matter of fact, we have to clear the sidewalk because we got people who need to walk by. But this is a big moment, Ted. This is a huge moment. I'll be here. I'm not leaving. I'm expecting something from this jury, whether it's after the question gets answered or maybe even before, Ted.
Yeah, you're right. These questions do give you the sense that a decision at the end of the verdict is coming, because once they get the answer to this question, assuming they are patient enough to wait, there's not much more to go. If indeed they're that low on the verdict form, that means they've accomplished a lot, and they have worked their way down to that question of drinking and driving, which is a question the defense would love to have answered in any way. They'll take it if they can avoid those top charges. Vinny, stay put.
Vinny, stay put. I think this is
If Mr. and Mrs. Reed have any comment. Hi, Mrs. Reed.
Hi.
Mr. Reed, any comment?
Not really. Not really.
How are you spending the deliberation time?
In prayer, and, that's about it.
Mr. Reed, your family looked visibly relieved. There was like an exasperation moment
Okay.
when you found out the question.
Yes.
Do you feel the jury's leaning a certain way?
Well, you just, you make inferences to the best you can, but you never know what anybody's thinking.
Are you prepared for a verdict?
Inside the courtroom.
I'm prepared to hopefully find our daughter free. Yeah.
Would
Tell me
just
about the
OUI be a
motion
win for
inside
your
the courtroom.
family? If it was just that lowest charge?
I'm not sure.
Okay. Okay.
Yeah.
Talk to me about the emotion inside the courtroom.
You can cut it with a knife, I think. Yeah. I've got to run,
Some
okay?
people were crying when they learned about the instructions or questions.
People,
Were people feeling emotions?
I didn't see any people crying. Unless I just didn't observe it.
What were you feeling?
Again, it's difficult to read into, what those questions were. I don't want to make any inferences or intimations from those questions. I mean, we're all reasonable people. You heard it yourself, and I'll just go with what I heard. But I mean, to extend beyond that, we'll play this thing out, come in back in about an hour, and that's how we do it. I mean, I've been playing this out for 3.5 years.
Did you feel the judge was responsive to what the defense said?
I'll let the attorneys respond to that.
Would you consider
Why
conviction, Bill, why they wanted you back at 1:30?
Yeah, I got. No, I'm not sure. I'm not privy to that.
He's like, dude, just leave me alone.
A win for Karen Reed?
I just want my daughter home. Yeah, and free. I gotta run. Okay.
Gotta run. Bothering.
Poor
me.
guy.
Yep. See what Boston
Jurors
is.
in the Karen Reed case have questions for the court in the second full day of deliberations.
And the judge has now sent back new instructions. We have team coverage for you, beginning with WBZ's Penny Commit outside the courthouse in Dedham. It was very interesting, Penny.
I'm going to step to the side.
You're right, Penny.
Did she step to the side? I heard her say
You're
she
right,
was gonna.
Penny. Let's go, rock and roll.
David Paula, good afternoon. Very interesting and still a pretty chaotic scene here outside of the courthouse. Several of Karen Reed's supporters are here. Karen Reed just exited the courthouse. She did not have any comment for reporters. It seems that the jurors have really only been considering Karen Reed's lesser charges, operating under the influence. They asked 3 questions related to it.
What is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The second, are video clips of Karen's interviews evidence? How can we consider them? And the third, does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? Okay.
Thank you. Otherwise,
So each side argued each question in order, followed by a ruling from the judge. Judge Beverly Cannoni opted not to give jurors an exact time for the OUI charge. As for Reed's media clips, the judge decided that they are going to be considered as evidence and that jurors are to consider them in whatever way they deem appropriate. Then as for the third question, this is one that was a bit tricky. The jurors asked if they, for example, find Reed guilty on only the lesser OUI charge under the manslaughter charge, would that convict Reed of the entire manslaughter charge? The answer is no. And as the defense has asked several times, the judge did decide that she will modify the verdict slip, and then she walked the jurors exactly how to fill it out. So the jurors have now been sent back for deliberation.
Oh, there's Paulo Glaze. Just went by the bathroom, glazed a few.
Oh.
I can say ever
Ooh.
since that question was
Blazing.
announced, the vibe out here has really gotten more and more intense. I would say more supporters even came out here, maybe after seeing the news online. So maybe we'll get a verdict by the end of the day. That's certainly what a lot of these supporters are hoping for. We're live in Dedham. I'm Penny Commit, WBZ News.
Hey, thank you. So let's bring in our legal analyst, Catherine Loftus now.
Yeah. Catherine, what's your take on the instructions the judge gave the jury?
She gone.
Because you can't, the judge is not allowed to explain any further about the evidence.
We're good to watch this, aren't we, D?
I have no clue.
What?
I said, I don't know.
Should be able to watch this on the news.
Sure.
Oh God. Oh fuck it.
It's really what the job of the jury is to take the evidence as they've reviewed it. You know, they can't ask specific questions about how to interpret it. Specifically, the question number one about whether are we talking about 12:45 or are we talking about 5 a.m. You saw that the answer from the judge was, you have all of the evidence and you're the fact finder. You have to make that decision, essentially. I do think clarifying the verdict slip, there has been much discussion about whether it was confusing or not. And I do think, given the nature.
Yeah. Let's see what this crazy one says about it. This one's crazy.
Under my opening statement, unreasonable doubt. Thank goodness that is not the standard in our criminal justice system. Beyond a reasonable doubt is. But I hear people misunderstanding and misinterpreting reasonable doubt all the time. What the prosecution must do is leave the jury with no reasonable explanation that is consistent with innocence. It's okay to have doubt. You'll have doubts. But if you can't get past your doubt, it's got to be one that's rooted in common sense and in reason. So here's an example for you. Recently, I came home to find my puppy Bella running loose in the house. Before I left for work, I put her in a crate. So how did she escape? Nobody else was home except for Rocky the cat. So did Rocky let her out? Of course not. That's an unreasonable doubt. Rocky doesn't have thumbs. He doesn't care too much for Bella, so he wouldn't go the extra mile to help her out. So then I had a doubt about myself. Was it my fault? Human error? Did I not lock her crate properly when I left the house? That's a reasonable doubt. So then I concentrated and I worked through what I knew to see if I could get beyond my reasonable doubt. So I thought to myself, okay, I distinctly remember shutting the crate door and locking it before I kissed her goodbye like I always do and handed her a treat like I always do. So then I took a look inside of her crate and bingo was his name-o. The inside of the plastic latch all chewed off. So without the latch to hold the door closed, little Bella was a free puppy. So in working through the evidence, I got beyond my reasonable doubt. And I became certain that Bella was the culprit and that Bella acted alone to do the escape. So my friends, the moral of that little story is doubts are okay, but they're not all reasonable ones. And even if they do seem reasonable at first, depending upon the evidence that you have to work through, you just might be able to reason your way past them to arrive at the point of certainty. So now we've got to find little Bella a good lawyer. That's my opening.
Yeah. That was enough of that. Let's watch the newest Be in Trouble video again. I don't think we watched this one. I think we watched the other one. But if we watched it.
Folks, understand something. If any part of that diffusion is gone,
What are you doing? Hold on. Come on. All right. Wait just a second. Back to that. For just a second. Too many tabs open. Clickety, clickety, clickety. Try it now. I think that's his video. Doesn't have any sound. Yep.
folks, understand something. If any part of that diffuser portion of the taillight is broken, there is no light.
Damn, look at that.
Once that plastic diffuser is broken, it's like a fiber optic cable. Even if you put another piece up to it, it lights up a little bit, but it never lights up like a whole diffuser. Once it's cracked, it looks like that. And it stays that way unless you replace this whole piece. Because once this is cracked, it's done. There's no more. It stops right where the crack is. But the light is still going down there. See how my fingers lit up? That light travels down the diffuser. But Karen's car is missing half of the one, and it's missing this whole one. See how the light stops? It just goes dark just by pulling the plastic away. Simple as that.
It doesn't illuminate at all. It's just black. Let's take a look at a couple of photos. At 5:07 a.m. at One Meadows, that's the photograph on the left. What do you notice about the right taillight? It's completely illuminated. Later, at 4:12 in the afternoon, photograph on the right, it's lit up. How can that be? How can that be if the Commonwealth claims that those diffusers The portion that lights up the light were already scattered all over 34 Fairview. That's their theory. But don't believe your lying eyes.
If you didn't catch that, I put out a video a month. I don't think we watched this a little while ago. I definitely want to watch this.
Jim, can I have that question, please? Thank you.
Let me
All right. So as council knows, we received a question from the jurors. If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? I got some input from the defense at sidebar, essentially saying if we could just ignore it. We can't ignore it.
Yeah, we watched it.
To me,
A month ago, don't trust your lying eyes. That was a reference to my video.
The taillight's completely lit up. That would be impossible.
The taillight on the left is exactly how Karen's taillight would look right now if you was to put it in her car. Now, if you see the diffuser where the red circle is, one diffuser is completely broken and gone. The other one is halfway broken. They damaged the light in such a way that the bottom LEDs don't work and the bottom diffusers are gone. So when her car is going down the driveway, it looks like the one on the right side, but in actuality, the way her light would look right now plugged in is the one on the left. As you can see down the driveway, that is a working taillight.
HD, a biomechanist, explained that at those speeds, the other side of that coin, John's arm would be basically destroyed. Contusions, swelling, torn ligaments, hyperextensions, dislocation of joints and bones, fractured, broken, and shattered.
Now let's go over my friend's arm here. First of all, those 2 bones are broken. That was from the impact. His wrist is, I can't tell if it's broken or not, but his wrist is, yeah, his wrist is broken. Dislodged a bone. His thumb's broken. Namely, that bone, or those 2 bones are broken. All right, y'all gotta send me some stuff to watch. Just send me some shit in Discord. We need to make 1 more hour, and then you can be free. You can have the evening and off. That's all I can do. It's the best I can do. Best I can do. Buffering. Don't send me copyrighted stuff and get mad when I can't play it. Okay? Don't do that. The elbow is messed up. It's protruding. It's got a big chip out of it. Two fingers are damaged. That one's broken through. So we've got 2 fingers, 2 broken bones there, broken wrist, and a chipped elbow. That's all from a taillight at 25 miles per hour. The taillight is indeed stronger than the arm, which I already figured it would be. Yeah, I see the next witness stuff. One of those is going to be pretty good. We're going to watch it.
But as you know, John's arm was pristine, save those dog and nail bites. He didn't even have a bruise.
Short attention span theater. Here we go.
Hear ye, hear ye, hear ye. All persons having anything to do before the Beverly Canoni, the Justice of the Superior Court, holding in Dedham within and for the county of
That's not me coughing. I don't know who that is.
Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Okay, so the first part he said is that you didn't really do any work for the NHL. You didn't really do any work personally for the Department of Defense. That was just what the company does, not what you personally do. Okay.
As a whole, yes, the work that we do, yes. Not you.
he starts by back at the you took
That
credit
would
for
be
shit you
prior to
didn't
my
do.
employment, yes.
Wow. That's where
Orca
we're
as a
going with
whole,
this.
yes, the work that we do, yes. As I said, I wasn't involved specifically in that project, no.
And you mentioned that you did some stuff for the company.
This is all you got? What? Your company worked with the Department of Defense before you got there.
You know what's coming. It's going to be, this is going to be nasty.
You lied and you said that you did this work.
And the fact that Hankey's even going there after Shannon, after the dude lied about having a bachelor's degree.
Really, it's not like you can't work in accident reconstruction without ACTAR certification, right, Shannon Burgess? Not like it really matters.
Yeah.
And you mentioned that you did some stuff for the company, does some things for the NHL.
Stuff and things
Yes.
for the NHL.
And you do litigation, insurance companies.
Yes.
Okay, see what he's doing now? He's planting the seed in the jury's mind that they were hired by Karen's insurance company.
Which is going to actually, I think, backfire in the redirect.
So Alan gets to come back and say, you weren't hired by an insurance company, right?
Yes.
And AJ should be able to get up there and redirect and say, you were not hired by Ms. Reed's insurance company, were you?
Hank Brennan opened a door that Alan Jackson gets to close on redirect that he wasn't otherwise able to close.
It helps the jury get to the truth. Why would you offer to leave it out?
Well, I didn't leave it out.
Wow, Brennan. What's important is helping the jury get to the truth. Yup, that is what's important.
No, but you offered to. You would have if requested. Why did you invite, why did you invite somebody else to interject?
So you see how he interrupted him? He said, excuse me, cutting him off again. Just rude. Like if I'm sitting there, I'm like, ooh, I'm cringing a little bit. And that wasn't the last time this happened during cross.
Again, it's because I didn't want them to get hung up on a statistic that just because we have more pedestrian impacts at night and in bad weather, that this alleged incident happened at night under bad weather, to give it more weight, to weight the evidence more because of that statistic.
His demeanor, like most of the defense witnesses, really good, even with that point. Didn't try to buck up. He's giving grace, right? Do it as a witness too. It helps, makes you look better. Brennan hasn't earned the snark with this witness.
You done? Yes.
Again, it's like, bro, that is not it. That is not it.
There are certain times as a lawyer when you can use a remark like that.
Brennan has not earned that snark with this witness.
I'm going to go with the gut instinct for 99% of lawyers is never.
This witness is not snarking at him.
I think we watched the Kelly Dever one. That's when Runkle goes fucking nuts. Didn't like that. Runkle he couldn't handle it.
Witness is answering his questions completely neutral.
Never do I have enough swag, enough riz, enough credibility with the jury to pull a fucking stunt like that.
Are you done?
You done?
Are you done?
Are you done?
Do you ever heard the terms confirmation bias?
Yes.
Do you know what confirmation bias is generally?
Generally, yes.
Do you think that you suffer from any confirmation bias in this case?
No.
Do you have any close family that supports one side over the other? Not the
Oh, we're
facts
going
of the
after the
data,
white.
one
Here
side
we
over
go.
the other. The facts of the data, but one side over the other.
Wife is up there.
Close family?
Yes.
Not that I'm aware of, no.
Wife?
My wife?
Why would you ask that question?
Yes.
I can't even believe he even said that. I can't believe he even said that.
Wow. I hope he says, yeah, my wife was harassed relentlessly by trolls on the other side because she apparently was commenting in maybe like a Facebook group that was like for Karen Reed. Oh, this is going to be great.
You better be watching your back real closely throughout the whole rest of this cross.
Look at his face. He's like, you want to come for my wife? You want to come for my wife? Come at me. Come at me. Let's go.
Newsflash to you, Hank. This might be something you've never heard or conceived of before, but a man's wife is a different person. She's actually her own individual.
My brother, whom I love dearly, might have very strong opinions. Does that impact my opinion? Is there any connection that I would even know his opinion because he's close family?
Husbands and wife They need not be a monolith when it comes to their opinions and thoughts and perspectives.
He just keeps hitting below the belt.
He's so dirty.
You know, to bring out, he actually presented Dr. Wolf with a printout of his wife's social media posts.
He's about to bring in her. He's so dirty.
Dean, how was the fried rice?
It was really good.
Where'd you get it from?
My mom made it.
Oh, nice.
Hell yeah.
Chicken, steak,
Chicken.
shrimp.
Ooh, I would have really liked if it was shrimp.
Oh.
Shrimp fried rice is so good.
At So Good? Is that where you got it?
What?
You said shrimp fried rice. That's So Good.
Shrimp fried rice? Yeah.
I
So
thought the
good.
restaurant- I thought the restaurant's name was So Good.
No, that's my mom's kitchen.
That's mom's.
She this is after the trial had ended. His wife joins the Facebook group, and all the women in there are like kind of are like, oh, Crash Daddy, your husband, you're a lucky lady, all this shit.
That is effed up. I mean, that's not part of our discussion. This is my profession. Is not something that I discuss with my wife and with my family.
This guy is a professional witness with great demeanor,
Especially when you're not allowed to discuss what you're doing.
answering honestly, and trying to focus on what he's there to do.
Dr. Wolf said, I don't know where my wife stands on this.
And then you didn't have the receipts to back it up, did you? You're going to try to impeach him with somebody else's Facebook?
No, I have not.
He's so
No.
dirty. He is so dirty.
And because he's never seen it and didn't have knowledge of it, Judge Cannoni did not let Hank Brennan to go any further.
This Brennan is the guy that gives all lawyers a bad name and why people hate lawyers. Okay.
Did you even go to law school?
Well, again, Dr. Rentschler is going to be addressing the. You're shaking your head.
It's because he's answering the question. I'm sorry. I'm not sorry. This is really frustrating.
So I'm going to.
I thought this feed froze. I literally thought my feed froze.
Dr. Rentschler is going to be addressing the. You're shaking your head.
So I'm going to let him answer the question first.
Injury component.
Rentschler's going to be addressing. You're shaking your head.
You're shaking your head. Like, it's so obvious, I think, to the people in the courtroom that this is just not how you want to act professionally.
That wasn't the feed. The witness is buffering in real time. You're shaking your head.
Would you want to know the body positioning?
It's irrelevant. Yeah, we dismissed it. We tested it and found it wasn't necessary.
Jackson clamped back with, he gave an answer every single time. She didn't admonish him. Because he's right. He's given an answer every single time.
Oh, so 5 times is good. 5 times
You
the
answer
charm.
that, Dr. Wolf?
No.
I feel like I've answered it the best I can, Your Honor.
Okay, next question.
You don't like that question?
Oh,
Yeah.
It's so gross.
there's disregard.
Okay. When you were doing these video,
Brennan said, you don't like that question? He's answered it again and again and again.
You don't like that question? You don't know. He just answered it like a billion times, and you kept trying to twist it into something else.
Oh, you don't like that question? Immediate objection, immediate sustained, immediate sustained.
Are you referring to the 95th percentile?
yes, I am.
Yes.
So there's a 12-pound arm. Mr.
Let's do them tandem. This is the closing arguments.
Hear ye, hear ye, hear ye. All persons having anything to do before the Beverly Cannoni, Justice of the Superior Court, holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts, This court is in session. Please be seated.
Well, hello, everybody.
Today is Friday the 13th, Friday, June 13th of 2025.
Day 33. And we really are at the end of the road, aren't we?
And it is the season finale of season 2.
It always means it's the end of a case.
We are finally at the end of the Karen Read case.
It was closing arguments from the defense.
I love closing arguments as an attorney.
These closing arguments were incredibly important.
I just find them to be utterly fascinating, and I love watching them.
Jackson goes first. And today, we are breaking down Alan Jackson's closing argument for the defense.
We're right at the end of the road.
The re-persecution of Karen Read.
Nothing left to do but sum it all up and hand it over to the jury.
Boy, did Mr. Jackson deliver a doozy.
Was one of the best closing arguments I've ever heard in my life. Literally one of the best I have ever heard.
It's time for closing arguments. Let's go. Let's go. It's time for closing.
Now, remember the theme that he started off with in opening statements?
There was no collision. There was no collision.
There it is.
There was no collision.
He came back to that theme. Really good. When you come back to the same theme that you set out in the opening statement.
Basically, what he's saying is the stuff I promised you in the opening, I am now delivering to you in the closing.
It kind of reminds the jury, see, we told you about this, and now we proved it.
I want to take a minute.
Thank you.
And
And sit
start
down.
off with thanking you. I want to thank you for your attention. I want to thank you for your patience. I want to thank you for your diligence. This is not an easy undertaking.
You always do this, always. Thank the jury. The jury's put a lot of work in. The jury has given up their lives.
Most of all, I want to thank you for your courage.
Didn't we watch this one?
Because courage is what this moment demands.
What?
Didn't we watch this one?
Not the this one came out one day ago.
I could have sworn we watched this.
No, and the other one came out 4 days ago. So I don't think we watched them. Definitely not on here. So if we didn't watch them on here, we didn't watch them. Yeah.
Toy is saying yes.
How?
We watched it yesterday.
Okay.
Okay.
Now back to this one.
11.86 according to the
Thanks
statistics.
for doing
You know
that
that, right?
Yes.
You looked it up.
Yes.
You didn't tell us that on direct, though, did you?
I wasn't asked. I don't believe I was asked that.
It wasn't necessary.
There is a crash test dummy arm.
It was about 10 pounds, yes.
No, it wasn't about 10 pounds. It was less than 10 pounds. Let's be exact. You're a scientist. Let's be as precise as possible when we're talking about data. It was less than
That's
10 pounds,
ironic,
wasn't it?
coming from him.
I think according to the spec sheet, I think it's 9.4 pounds total.
How about 9.38? You keep coming up a little bit.
Oh no. 200ths of a pound.
Mark?
The arm that he used was lighter, lighter than John O'Keefe's arm.
Right.
Using the lighter weight arm is the more conservative approach.
And Brennan is blaming him for using a lighter arm.
Because it's not trying to add more weight to break the taillight.
Wouldn't the damage be less under the logic that he's putting forth now?
Whatever they did, it was going to be criticized. Use a heavy arm, don't use a heavy arm. Either way, you did it wrong.
Hank can just make up any facts he wants and make witnesses for the defense try to adopt him. If not, he's trying to make it look like they're lying. So it doesn't work that way in a real court.
Well, is Dr. Welcher changing? I don't know if, I was relying on what he provided
This
in
isn't
his
on
report.
Dr. Welcher. I'm asking you.
Objection is on Dr.
No, it's not.
Okay, so jurors disregard that exchange between counsel. Next question.
Oh, the kids are fighting.
This isn't on Dr. Welcher. Objection, it is on Dr. Welcher. It is not. Nuh-uh. Yeah-huh.
This isn't on Dr. Welcher. This is on Dr. Welcher. All right, children, stop.
I know you are, but what am I?
Don't come at me later and start, oh, well, what if it changes? Well, what if it fucking changes?
I'm
It
going off
changes-
what Dr. Welcher said.
Yeah.
That's your expert.
Yeah. Yeah.
So if I'm wrong, that means he's wrong.
Yep. And I guess we got to do all this shit again.
Again, I haven't reviewed anything that indicates that there was a different orientation that Dr. Welcher suggested.
You're a scientist, right? You can think.
That was snarky as.
I'm asking you.
You can think. Oh my gosh, guys, this is.
I'm asking you.
You can think.
Just a general question over here.
What
Change the
an
result.
asshole.
If you bend the
Over
arm-
here, he did the same thing. Over here, over here.
He is so unprofessional.
He's so rude.
And I don't care how skilled you are, how frustrated you are. You're a scientist. You can think, and then says over here, and she says nothing.
He's not been chastised, admonished, nothing whatsoever. Bev has no control over his misbehavior, so he continues to engage in it.
You got the judge in your corner right now.
She just tolerates this.
Well, because he runs roughshod over her, because what you allow continues, and she just allows it. It's like she has no control over this courtroom.
Pretty much just like you see with an indulged child. You have no boundaries with a child. What do you get? You get a spoiled, bratty kid. And that's what we're seeing in this courtroom.
Nope.
If you
Don't
bend
answer
the
it.
arm,
Don't
would
answer
it
it.
change the result?
Don't answer it.
It could.
Thank you.
All right, so we'll tandem it with something, Dan. I found something.
Oh, what?
What? I just found. We'll just do a little bit of his actual testimony.
Last name spelled Wolfe.
May I inquire, Your Honor?
Yes.
Dr. Wolf, what do you do for a living, sir?
I am the director of accident reconstruction at a company known as ARCA, ARCCA.
And I'm going to start right off the bat, get really comfortable with that microphone. It's adjustable. Pull it right close to the area of your chin. It's really loud in here.
What's he doing? What's he trying out?
Dr. Wolf, you said you work for ARCA, ARCCA. What is ARCA?
ARCA is a forensic engineering consulting firm.
Dr. Wolf, could you please state your entire name and spell your last name for the jurors, please?
Daniel Michael Wolfe, last name spelled Wolfe.
May I inquire, Your Honor?
Yes.
Dr. Wolf, what do you do for a living, sir?
I am the director of accident reconstruction at a company known as ARCA, ARCCA.
And I'm going to start right off the bat, get really comfortable with that microphone. It's adjustable. Pull it right close to the
There we go, Dan. Well, now we can just talk for about an hour.
Cool.
So, is Cherry able to keep up with anything? I haven't seen her anyway.
No, she's been busy, man.
Well, hopefully she can watch the updates every day.
Yeah, no, I think she's just dealing with other things.
Yeah. Well, it was nice talking to you. You done?
No.
Huh?
No.
That was it?
No.
Thanks. When you pick out a co-host, pick one out that's chatty.
Yeah.
No. That could come back to get you too. That could be worse. Right, Dean?
Yeah.
Y'all realize how like Inception that is? If you are saying that even this hypothetical that is being posited, that your alternative scenario is a reasonable probability as an alternative to what Dr. Wolf is presenting, then wouldn't you say that you have failed to present your case as proving something beyond a reasonable doubt? Because you yourself are trying to interject this as a reasonable doubt to his hypothesis? I know that was a weird way of saying it. I don't know if I can artfully clean that up.
I like how he tried to fool the jury by showing just the that one left sleeve of the crash dummy that went flying in the final test.
Pavement's hard.
Pavement hard.
Yes.
How about frozen ground? Frozen dirt?
Is that
Oh,
hard?
wrong guy.
I suppose it can be.
Well, do you have any doubt whether frozen ground in the
Science is
Northeast
hard.
in the winter is hard? Hard as a rock.
Not like that.
I haven't done any analysis to assess that.
A lawn with green grass and dead grass on there that provides a big cushion barrier, even if the ground below is frozen.
And so seeing holes in those clothes
And
is what
frozen
you would
grass is
expect.
Let's watch this again. 'Cause this is hilarious.
And to get back to the airport, they had to take other people. And so they were having a lunch afterwards and they said, come have a sandwich and then your ride will take you to the airport. So I went and I had a ham sandwich.
Did you testify at some
Ham
point that
sandwich.
after you had something to eat, you just stood in the corner?
I did. I just sat at a table, ate, and then went over and literally stood in the corner waiting for my ride.
When you sat at the table and eat, did you just eat your ham sandwich? Or did more go on?
I ate. People were talking. I really didn't talk much at all.
Did you listen?
Certainly, I'm sure I did. So. I assume if something funny was said, I probably laughed.
Did you talk about your testimony?
At this point, I don't even remember.
Did you stay independent?
Oh, I can't. This is my first time hearing this. This is my first time hearing this. Oh my God. How embarrassing. Lally never did anything like this. Oh my God. That is the funniest thing I've ever heard. Wow. Did they teach that one in law school?
Waiting for my ride, and to get back to the airport, they had to take other people. And so they were having a lunch afterwards and they said, come have a sandwich.
Come have a sandwich.
And then your ride will take you to the airport. So I went and I had a ham sandwich.
Did you testify at some
Ham
point that
sandwich.
after you had something to eat, you just stood in the corner?
I did. I just sat at a table, ate, and then went over and literally stood in the corner waiting for my ride.
When you sat at the table and eat, did you just eat your ham sandwich? Or did more go on?
I ate. People were talking. I really didn't talk much at all.
Did you listen?
Certainly, I'm sure I did. So. I assume if something funny was said, I probably laughed.
Did you talk about your testimony?
That shit's hilarious.
Actually,
After
pretty slick.
Randy
It's
hits
not
that
going to
hard
rain
ground,
like that.
right?
We're really going to call him Randy, aren't we? We're just-
Look at all the dirt. There was no dirt around those bite marks on the sweatshirt. Can we just point that out?
look at the size of the holes and the I mean,
Are you talking about frozen grass or paved?
I'm talking about Randy right now. These holes in the clothes are what you would expect after Randy hits the hard ground, correct?
I can't do trial 3.
No,
I can't do it.
hard ground
Can't do
is not the same as pavement. This is specifically pavement.
So he's trying to get him. He's trying to get the jury to think like, oh, okay, so if Officer O'Keefe got hit just like this and he fell on the grass, well, this would cause all that damage. But again,
Frozen grass or pavement. Yeah, a lawn or pavement. It makes a big difference. But Brennan tries to make those things sound like they're the exact same.
we know the difference between tears in clothing, ride-alongs, and puncture wounds.
And then he also showed Rescue Randy. Now, Rescue Randy was when it was the direct impact.
That was not a clip. That was a full impact.
That was a full impact,
That was
right?
a full impact, yeah.
Where the entire Lexus was smashed to smithereens.
And that whole backside is smashed in.
Yeah, a clip is a little piece of you gets hit.
Rescue Randy went flying backwards.
My man, Rescue Randy, needs to go to the ER.
You're muted.
Tell us the story, Dean.
Fuck no.
Not that kind of story.
I ain't telling you she.
Dang, man.
No. You tell me a story. You're older.
I'm trying to find a story of something we can watch.
How's it going?
Pretty good.
You find anything yet?
Yeah, found something. You ready?
No.
Why do you always say no? I mean, either you're ready or you're not.
Well, I just answered your fucking question. I said I'm not.
Okay. It doesn't matter if you're ready. This is where the train's going.
Yeah, Morg says, tell us a fucking story.
No, Morg. Morg. Hail Morg. Everybody say, Hail Morg. Don't type it in the chat. Just say it out loud at your house. It's fine. You don't have to type it in the chat.
Perspective from police after 2 officers took the stand this week. Canton Confidential, the Karen Reed murder
Okay, I'm gonna be honest.
starts.
Yeah.
I personally wouldn't play anything from NBC.
Oh, that is NBC.
NBC
We'll just
really
do it.
doesn't like their stuff being played by other people.
What do they do? Send people out to hurt you?
No, they usually just strike.
Strike fast. Strike hard. Are they in the Kumite?
Think about
And,
this.
Cobra
Mhm.
Kai?
Yep.
Cobra Kai members?
Yeah.
No mercy. Sweep the leg.
Think about that photo of those x-rays as you deliberate. You can manipulate a taillight fragment. That's not that hard. You can't manipulate a bruise.
Somebody in the chat tell me where the hell these damn x-rays were during the first trial. Because I don't remember seeing them. And I don't know how they got in right here at the end without somebody getting in trouble. I don't know what happened.
If they claim the car was going fast enough to shatter the taillight and shatter the diffusers, then it was also going fast enough to destroy and shatter John's arm, and it simply did not. How do they square that? They
Wait, could you pause it?
can't. So they spent nearly 400.
Mm-hmm.
Misty says it's fine. Duty Ron plays it every stream. I just know, like, from my experience playing NBC stuff, I've been struck.
Yeah. It just depends on what it is, probably.
But if she's saying it's fine and other people do it,
Yeah, Misty knows all about it.
then maybe we could watch it. I just know, like, I've had experience with NBC.
Well, this is a pretty good Be in Trouble video. I'm not sure we've seen this one.
Okay.
But I say that a lot because I watch.
Dude, you just played like you just played something. Like, I'm pretty sure we watched this. How could we have watched it?
Yeah.
It just came out yesterday.
That's what I said.
Yeah, I know. I think I do a pretty good
I don't think I was
impersonation of
that
you.
dramatic. I don't think I was that dramatic about it.
I'm pretty sure I'm a good. I think that was like spot on, bro. How could we have watched it?
That sounds like a character.
It sounds like Forrest Gump.
No, it's the dude in come on, the one where I'm just a dude playing a dude pretending to be another dude.
I'm the dude playing a dude disguised as another dude. Yeah, that was Robert Downey Jr.
Tropic Thunder.
Yep.
Yeah, Ben Stiller's
What are you talking about, you people? What are you talking about, you people? That's such a good movie.
I think they get it. They get it.
No, they don't.
$100,000 of taxpayer money to hire someone to dress up and look like John and paint his arm blue, which told you exactly nothing. The ARCA testing, conversely, also established that it is impossible for John's sweatshirt sleeve.
Pretty sure y'all believe that we've watched it because everybody's got the closing in there, and they're like, "Oh, we've seen the closing." I know this is not the closing. This is a Be in Trouble full video. But we could have watched this too. I don't know. Who keeps up with this stuff, Dean?
I'm pretty sure everybody here.
To be damaged by an impact with the taillight. The Commonwealth's theory is that the sleeve of John's hoodie sweatshirt was damaged by flying shards of taillight slicing through the shirt and through John's arm. I have 3 questions. Number 1, John's arm had about 36 abrasions. How did 36 shards of acrylic go through 9 tiny little puncture holes? How'd that happen? Somebody needs to answer that.
It just did.
Number 2, why are there no slices or cuts in the hoodie? All the defects are punctures. Punctures that you might get from, say, I don't know, canine teeth.
All of these holes are in pairs. You can tell they're perfectly round, the same as dog teeth. That's exactly what they are. These are dog teeth. There is no way a car could do this. A car would cause tears and rips and would actually cut the material.
And number 3, if the shards cut bloody gouges into John's arm, that's their theory. Why is there no blood, no skin, no tissue on a single shard of taillight that they claim came in contact with John's arm? The Commonwealth cannot answer a single one of those questions because John's arm was not impacted by the taillight. It doesn't make sense simply because it didn't happen. Compare and contrast the ARCA experts and their actual testing to Judd Welcher. He came to you in the Commonwealth's case in chief, and he told you that for the better part of $500,000, he'd come in and testify that John was tall enough to
$500,000.
touch the taillight with his elbow. That's it. And even in that basic
He
demonstration,
sold them 1 pint of blue paint for $400,000. That's a smart man. Very smart.
he had to lean in to manipulate it, to get the results that he wanted. It was completely inverted, flipped backward, completely false. The test that formed the basis of their entire theory of the case. Watch closely as Dr. Welcher stands as a surrogate. Is that a righteous test, or is that a manipulation? Dr. Welcher tried to deceive and fool you by leaning into the car, manipulating the results of his own test. When the truth was revealed by Dr. Rentschler, the Commonwealth spent the next hour cross-examining it about how that test was meaningless. It actually didn't mean anything. Well, that's convenient now that we realize that it was a manipulated test, and it actually does mean nothing. It didn't represent the theory of the Commonwealth's case. That's what was suggested. That test does not represent the theory of the Commonwealth's case. Really? Then why was Dr. Welcher playing dress up in John O'Keefe's clothes, or identical clothes to John O'Keefe, when he was holding a glass? Why was he holding the glass right behind the vehicle? And why was he standing with his right arm oriented to the right rear taillight if he wasn't trying to recreate the circumstance that is the Commonwealth's entire theory? The Commonwealth stood up here with a straight face and told you they weren't trying to suggest that that's how John was hit by the car. Of course they were trying to suggest that's their theory of the case. They only abandoned it 2 days ago when it was revealed by our experts that it's physically impossible. That silent witness, that science, that physics has become very pesky to the Commonwealth because there was no collision.
Every time I listen to Alan Jackson's closing, it gets better.
Yeah, we're gonna watch it 10 more times.
The first time I heard it, I was like, "Damn, that was kind of lackluster." But every time, it's more and more.
You're like one of those slow learners.
Yeah.
You just
I
gotta.
listened to it 28 times. I can just recite it to you.
We're gonna watch it 100 times.
No, there's just 17 more times till we get to 28.
100.
117 more times.
420. We're gonna watch it 420 times live on
that
air.
Could be done. That could be done. Let's go.
All right, let's do it.
Dr. Welcher also told you under oath
This is
that
not
there were no x-rays taken of John's arm. He tried to deceive you into believing that John's arm might have been broken. I don't know. I didn't see any x-rays, so I can't tell you what the damage was inside the arm. Really? The Commonwealth has had those x-rays in their possession for 3 years. And again, it took the defense to bring out the truth. The x-rays do not fit the Commonwealth's theory, so you weren't shown. And Dr. Welcher wasn't going to admit it. And my goodness,
What you are looking at is John O'Keefe's x-rays, not a single broken bone, not a single torn ligament.
Dr. Welcher then claimed that the reason he didn't do the reconstruction, the actual testing, think about what he said. There isn't enough evidence to determine what happened. I beg your pardon? What happens when there isn't enough evidence, in his words? You vote not guilty. That's what happens. John O'Keefe was inside, and the phone battery temperature further proves it. This is not speculation. This is science, and it's irrefutable. It tells us that he was not laying outside in the cold. He was inside somewhere a little bit warmer. Ian Whiffen told you that when the iPhone is exposed to freezing temperatures, think about these numbers. When the iPhone is exposed to freezing temperatures, it will drop from 81 to 21 degrees in 15 minutes. 15 minutes.
Now, I'm not going to make everybody sit through a long video and just watch a temperature gauge. So
I
I'm going to
will.
speed it up to time.
Do you know that, Dan? I will make you sit through a long video.
Dude, I think you should play it at half speed. Let's make this video longer.
That's perfect.
Times 10. And I'll let you know now that it got down to the low temperature in 7 minutes and 8 seconds. Before I stopped the test, it would probably go -0 if I let the test.
This is the way to get a lot of watch hours right here.
If I had
He sounds like a dumber Forrest Gump.
cold enough,
If I was cold
I
enough.
was just using
Oh god. All right,
a regular fabric. I guess a cold compress that was in the freezer, and I think it was 20 degrees. But you'll see how fast the phone gets down. Now, the temperature gauge, the first line is the back of the phone. The second line is the side of the phone. The bottom line is the actual battery temperature. The phone is under my back with the phone touching my back and the other part of the phone on the compress.
That's a 60-degree drop in 15 minutes. Now look at John's phone. It was laying, according to the Commonwealth, it was laying directly on frozen ground. He arrived at 34 Fairview and his phone dropped only 20 degrees over the course of an hour. Then inexplicably, it stayed steady, never dropping below 50 degrees for the next 4.5 hours, never dropping below 50 degrees for the next 4.5 hours, basically through the entire night. He was not outside. He was someplace warmer, like a basement or a garage. Dr. LaPosada confirmed that John O'Keefe did not have hypothermia. No telltale signs, no telltale Wisniewski spots, no frostbite on any extremity. He did not die of hypothermia because he wasn't outside. Dr. Isaac Wolf, Dan Wolf, Elizabeth LaPosada, Judson Welcher, Andrew Rinchler, all agreed. Every expert agreed. This is how John O'Keefe died. A rearward fall from a standing position. What could make you fall straight back like that? Let's just think about that for a second. What could make you fall from a standing position, as Judd Welcher just showed us? Standing up, falling straight back.
I'm gonna do something.
Add a laceration to the right
nobody
eye, consistent.
ever done before. Put Alan Jackson in super slow mo.
Fist or punch.
Too slow.
And you've got your answer.
Alan Jackson on Gummy.
He certainly didn't sustain that wound on the back of his head by falling backwards onto a lawn. Dr. LaPosada told you that the patterned injury on the back of John's head could only be produced by hitting a hard, ridged, or ledged surface, like a concrete stair or step.
Yeah, Petty says he sounds like you now, Danny.
was just through that garage door. Michael Proctor never stepped down in that garage to find out. What a shame. You don't need the top experts in the country, but you had them. You don't need
Tried
the top
at
medical
3
minds on the planet
times
on this issue,
speed.
but you had them. Dr. LaPosada told you in probably
No.
the clearest voice in the entire trial.
Come
You remember her
on.
testimony. He didn't get hit by a car, in her words. He just didn't get hit by a car. You remember the question that was posed by Mr. Brennan, did you consider the speed of the vehicle? And she said, speed didn't matter because he didn't get hit by a car. She repeated it 3 times because it's true, not just because she says so, but because the medical evidence proves it. The medical science proves it. There was no collision. Contrast that with the caliber and the quality of the experts who came in here to tell you what is obvious to anyone with common sense. Those wounds on his right arm are from a dog. This was not an oversight by the Commonwealth. It's just there is no one out there. No matter how big a check you write, there's not a medical expert who's going to disagree with that. The fact is, this is the central fact in the case. The only fact that matters is literally uncontested by every medical expert. Uncontested, undisputed. There is no evidence that John was hit by a car. None. How much more reasonable doubt could there be? This case should be over right now. Done. Because there was no collision. So given all that, how did Karen Reed end up sitting here? Why is she even here? Why is she in that chair? Why is she in this courtroom? There is a reason for that. And it's a reason they don't want to tell you, and it's a reality they don't want to admit to. The reason we're here is because the system, the very system that was meant to protect her, that was meant to protect all of us, that system has failed badly. So now let's discuss the facts that were and were not presented by the Commonwealth in this case. Over the next few minutes, I want to talk about the utter failure of the police to investigate this properly and to investigate this fully. And what you're going to see is that Michael Proctor, the lead investigator for the Commonwealth, did nothing to actually and properly investigate this case. Let's start with the house. That's the most logical place to start. I think you'd agree. Brian Albert's house, where John's body was discovered lifeless in the lawn. The police officers found dead on the front lawn, and no one secures the scene. No tape, no
cases. You'd have to go back and actually study the cases and look at the details.
Having experience in pedestrian collisions, you can't think of a similarity between cases as far as vehicles and speeds and totally different injuries occurring.
I'm going to allow that. Can you?
Do you mean hit the same way with the same type of car at the same speed with the same force?
I'm going to allow it. Can you answer?
I don't believe I've ever seen a case where 2 people were hit with the same car at the same speed with the same force with different injuries. I don't even know if you can correlate that.
Looking at Exhibit 1, have you done any study about the directionality of glass or broken plastic?
What do you mean by directionality?
About when something shatters, how it shatters. Does it shatter the same every time, or when plastic shatters, does it shatter differently?
It certainly depends on the impact.
Do you have any studies where plastic shatters exactly the same way on different impacts?
I doubt that it shatters exactly the same way.
It has a lot of different variables, doesn't it?
It could.
Depends on a number of different equations, doesn't it?
Well, it depends on the testing you do. If you want to see how it shatters, and if you're claiming that it shattered in a certain way to cause a certain injury.
Do they have the damn lights off, or is that something I did? Because I don't think I did that.
If you don't have any peer-reviewed evidence, if you don't have any research, then you have to do the testing, because you can't just say, well, it's possible it could shatter this way and cause that injury. That's not conclusive. You can't use that to come to an opinion about what happened.
Oh, that wasn't what I was asking you. I was asking you if you have seen in cases that when plastic breaks, it breaks differently.
Well, sure. I mean, the testing we've done here, the taillights covers fractured differently, and we didn't get any contact. So I have personal experience just with this case alone.
We'll get to the contact. When you look at all the tests she did, the plastic broke differently in each and every case, every experiment, didn't it?
Sure, it's broken like that, and I've never seen a case where you get these types of abrasions.
I didn't ask you that. Is that funny?
It's not funny.
Okay.
So I'm going to strike the comment. Next question. Next question, Mr. Brennan. No more comments.
When you did your
Never
experiments,
do it again.
the sizes of plastic that broke were different in each experiment, weren't they?
They were, yes.
The number of breaks in each experiment were different, weren't they?
They were, yes.
the angles of the brake changed from piece to piece, experiment to experiment, didn't they?
I'm sure they did.
Did you watch the videos and watch the damage and take a look and count how many pieces broke in each experiment?
I didn't specifically count. No, we looked at contact to the sleeve and to the dummy itself.
You never counted the broken pieces in each experiment?
I did not. There was no need to.
Not matter if there's a need, did you?
I did not. No, sir.
You had talked quite a bit about Dr. Welcher's test with the paint, so I want to ask you some questions about that. Were you ever under the impression that Mr. Welcher, you can take that down, please. Were you ever under the impression that Dr. Welcher was trying to reenact the actual collision when he did that blue test?
I'm going to allow it.
Well, that was the only test he performed, and he referenced that test for his opinion that the position and orientation of the lacerations are consistent with the taillight cover. So if that test was not intended to signify or demonstrate the position of the arm, he has no evidence to say the position and orientation of the arm in the lacerations, which are abrasions, are consistent with the taillight cover. That's the only test he did. So if it doesn't represent that, it's really meaningless in his analysis and conclusions.
Now that you've shared your opinions, can I get back to my question?
So here's a good part of the Canton Confidential.
This of the witness made clear by the dizzying number of objections by the Commonwealth while Dr. Daniel Wolf was on the stand. Almost as numerous as the objections were the visual displays for the jurors. In video after video of accident recreations, Wolf showed their testing methods.
We applied this same linear impactor to be able to project, if you will, or accelerate the taillight at a known speed into the ATD arm.
Showing what happens when a taillight collides with a dummy arm at various speeds, saying the damage to the taillight was inconsistent with the damage to Karen Reed's SUV and inconsistent with the damage to John O'Keefe's clothing.
In any of the testing that you did you ever see taillight pieces cut, puncture, or fray the sleeve of that hoodie?
No.
Often displaying side-by-side images of the actual damage and damage that resulted from their testing. Here they are talking about testing done at 24 miles per hour, the same speed the prosecution is alleging Reed was going in reverse when the SUV hit John.
We accelerated that vehicle into the arm at 24 miles an hour.
Were you able to reach any opinions or conclusions as to whether the damage to the subject taillight is consistent with striking an arm at 24 miles per hour?
Based upon the test results, it's inconsistent with striking an arm.
After each test showing the damage to the taillight, the arm, and the sweatshirt.
It's inconsistent. It was inconsistent. It was inconsistent.
The doctor was asked about the so-called blue paint test done by the prosecution's witness and about its efficacy.
Doing this at 2 miles an hour doesn't tell you anything about, well, what happens at 10? What happens at 15? What happens at 20?
And what he says Welcher didn't do.
I'm not aware of any impact testing that he did. No.
Under cross, Hank Brennan immediately going after his credibility, then his prior communications with the defense.
Is there any reason why you deleted all of your text communications with the defense?
Just I routinely delete them after that communication is over with.
And potential bias.
You were communicating with the defense and attempting the best you could to assist their cause, weren't you?
I wouldn't characterize it that way.
It got heated a number of times.
I feel like I've answered it the best I can, Your Honor.
Okay, next question.
You don't like that question?
Strike. Jurors disregard.
On redirect, Jackson went back to the science, asking again if the injuries to John O'Keefe's arm could have been caused by shards of taillight.
They would somehow have to accelerate with more speed to catch up and go beyond the arm, essentially.
Is that physically possible?
No.
All right.
Test and see how much damage the taillight actually sustains. This is a direct elbow and arm hit at 24 miles per hour. Watch the taillight pieces. They go straight back about 15 feet, straight to the ground, following the vehicle. They do not go toward the passenger side of the car and outward. They go back and downward. And then Randy's going to get another hit in the elbow, and boom, you can see the pieces fall directly to the ground and back, following the direction of travel of the vehicle. There's a direct impact with the arm. Watch the arm. It's going to whip the body around. The taillight pieces are going to fly back and toward the ground, not toward the right side of the vehicle or passenger side, but straight back into the ground. The body's going to spin and would have fallen down.
So this is a overall photograph depicting the taillights subsequent to this test at 24 miles per hour. I will note that there is a taillight, and then there is damage to the quarter panel taillight.
Is there any damage to the internal diffusers on this taillight?
So if I go to the next photograph, if I may.
Please.
So you can see here, there is this kind of thicker, it's actually not a crack. So I'm looking at the clear diffuser here with the dots that you see. This line that you see, kind of opaque. I don't know if you've got a laser pointer. So the line right here that's part of the assembly. So that's just a part of how the plastic is molded. There's a very small crack right here in the underlying diffuser, but all of the remaining part of the diffuser in terms of this portion here and here are all intact, and same with this portion of it.
What about the chrome piece that's running between the diffusers?
I don't believe that was damaged during this test, no.
And what do you know? Inside of the taillight lens is an actual piece of the taillight. If you look closely in the circle, it is a piece inside of the taillight.
What is this depicting?
So this is a photograph depicting the quarter panel taillight subsequent to the 24-mile-an-hour impact test with the ATD arm compared to that of the subject taillight.
Based on this test, were you able to reach any opinions and conclusions as to whether the damage to the subject taillight is consistent with striking John O'Keefe's arm at 24 miles an hour?
Based upon the test results, it's inconsistent with striking an arm.
This is dumb. And hopefully the camera caught that because I don't have a fixture for the other side taillight. There's 1, 2 big pieces, 3 big pieces, 4th big piece, no clear plastic, no diffuser, no inner parts of it whatsoever. The arm is still intact. We'll examine that in a second. The car hasn't moved since it stopped. That is exactly what it did to the taillight. That was exactly 25 miles per hour.
So, Mr. Jackson, Mr. Brent, I'm going to see counsel outside now.
Dr. Rensler, you wrote a report back in February 2024.
That's correct. Yes, sir.
And in that report, you provided a number of opinions, didn't you?
I did. Yes.
Do you remember if you opined or had the opinion that the injuries on Mr. O'Keefe's arm would not result from impact with a non-damaged tail lamp cover?
I believe that's correct. Yes.
And the amount of force required to fracture the tail lamp cover would result in extensive soft tissue and likely bony injury to Mr. O'Keefe's right arm.
Correct.
And so your opinion back in 2004 was that if a person's arm were to cause the damage to that taillight on that Lexus, you would expect to see extensive soft tissue and likely bony injury.
Yes, soft tissue referring to ligaments and tendons of the elbow and shoulder, correct, and the wrist.
And so you're saying not superficial abrasions, but in the arm?
Yes, when you look at, and you can see from the testing we did for this case, for this round, that the arm extends and you've had contact with the arm, you would expect at those speeds damage to the tendons and the ligaments, the elbow, the shoulder, likely the wrist.
And the x-rays that we looked at or that we saw, and you offered the words of the medical expert, there is no MRI studying any ligament damage, is there?
There are no MRIs that I'm aware of, no, sir.
And x-rays wouldn't fairly depict some of those internal injuries that you're referring to, would they?
As I described before, it can show laxity of the joint, but it normally doesn't show the actual soft tissue damage itself, no, sir.
And a crash test dummy is different than a person, isn't it?
Certainly it is, yes.
No
sir.
muscle.
That's correct.
No ligaments.
That's correct.
The crash test dummy does not react or respond like a human being.
Well, it does to a certain extent, yes.
There are differences.
Certainly there are, yes.
And so when you're looking at a crash test dummy, you can agree that there are significant differences between what you might see on the dummy's arm and what would maybe happen to a human being's arm on the inside.
There can be. That's why you have to look at the acceleration and the force, and that's primarily what the ATD is utilized for.
But focusing on the actual observation of the arm, you would agree, doctor, that looking at a crash test dummy arm is not comparable to actually looking into a human being's arm with an MRI and seeing if there's any damage on the inside.
No, of course, they're not the same. No, sir.
You were speaking about references earlier. You did have a chance to see Dr. Welcher's report, didn't you?
I did, yes.
And in his report, there were a number of references, weren't there?
There were different references, but I think maybe 26 within his report.
In addition to his references, you were sent a number of gigabytes of information, weren't you?
I was, yes.
And in those gigabytes, there was different references to different materials, wasn't there?
Well, first of all, there were only 26 references in his report that he cited to for his opinions. There was material contained within the batch of documents that they sent over. There was a bibliography or CV of different papers that he had submitted, I think 20 pages of papers that weren't referenced in the original report. And the most recent paper in that AutoPed packet was from 2004. Most of them were from the 60s and 70s, but there was an additional packet of information.
When you read his report and saw his references, did you look up the references?
I did, yes, sir.
Okay. And when you were saying earlier that there's only one reference, you were referring to the pink test, correct?
Well, I was referring to, there's only one reference specifically with respect to automobile pedestrian impacts.
When you looked at his references, sir, did you have an opportunity to read any of the articles?
I did, yes, sir.
And many of them are peer reviewed?
Yes, sir.
In addition, when you looked at the 20 pages of materials he sent over that were not in his report, how many references did you read out of those 20 pages of references that he offered?
Well, I didn't read any because they weren't referred to in his report for his actual opinions in this case.
Do you know whether or not he considered those references or whether he read those references?
I'm going to allow that.
He didn't cite to any of those references in either the PowerPoint presentation or in his report. That's the knowledge I have of whether he reviewed those.
So you don't know what he considered or thought, do you?
I know what he cited to and he referenced to in his report in PowerPoint. That's the extent.
The question is, you don't know what he was referring or reading or relying on other than what was in his report cited, correct?
Well, right. If he referred to the other articles, yes, certainly other articles in the 60s, 70s, and 80s he may have, but they don't really pertain to what happened in this case.
How many references were in your May 7th report?
Well, I think there were... Uh, 26, I think.
Those 26 references, are they offered in your report to suggest some type of...
What's up, Lolly?
Hey guys.
Yo.
We just hit the 3-hour mark with
I
zero
know.
content. Zero content. I was just trying to catch the
No, your content has actually been really good today. Like it's been really interesting, honestly.
except for
There was
Dean.
a lot I haven't seen yet.
All Dean says now is no. No.
No.
No.
Oh, you
No.
brought
I
up
think,
stuff I
I think
haven't
only
seen.
your frogs may have inserted themselves in Dean.
No. Oh, my frogs. I thought my motion detector is making a funny sound out here, and it sounds like a sick frog. I thought y'all could hear that.
Usually means fire when the smoke detector's making a funny sound.
Motion detector.
Oh, motion.
Yeah, like the battery's low, and it's got like this reverb on it, so it sounds like
Yeah.
a sick frog.
If you live next to the ocean, you know there's a lot of motion in the ocean. They could probably set that off.
And cake by
Ooh.
the ocean, and what else are we gonna do with this?
That was it. I didn't have anything
Okay.
else.
No,
But
your
Ooh, that was a
content has been
terrible
good.
joke, Danny. I'm shaming you live.
every joke can't be great, Dan.
Well, it'd be nice if one of them was good at all.
Yeah, Dean's got jokes now. Did your Adderall kick in or something?
No, his fried rice has fulfilled his
Oh,
system, and
yeah.
he's good to go.
Oh, I got the energy.
I'm alive again.
Thanks to
Was
the
that
rock.
leftover fried rice, or did she make some
Oh,
more?
yeah, it's fresh.
No, that was leftover. That was from like 2 nights ago.
Yeah, and
Never mind.
Fried rice is good, heated up like over and over again too.
Yeah, it's a lot like lasagna in that sense.
Yep, spaghetti, over, yep, all that stuff.
Yeah, it's great how the rice gets really hard and crispy in the microwave. And it's hard to chew.
That sounds like you don't know how to make fried rice. That's what that sounds like.
Watch this video. And shut up.
Morning.
I love fried rice.
What up, Morg?
Morg. Morg. Pinky just ordered pizza for everybody. Yay. That's what Gingy used to ask me in the chats all the time when I first started hanging out with her. Was what was Toy cooking for dinner? Every time I would see her, what's Toy cooking? I guess Toy was talking about cooking or something one time. She thought she cooked a lot.
So I speaking of fried rice, I once went on a date to this Chinese food restaurant in Berkeley, and the name of the restaurant is King Dong.
Did you get a souvenir cup?
No, I wish. But yeah, King Dong in Berkeley.
King
When you
Dong.
said Berkeley, that just reminded me of that college I was trying to think of, and it was UC Davis. When we were talking
Okay.
about San Luis Obispo, yeah, UC Davis.
Yeah.
That's where my professor went to school. That is pretty funny though. Like we passed a new casino that just opened here, heading in for Mother's Day, and one of the Oriental restaurants. Like if a child was pronouncing it, it would have come off bad. It was like FAKDO or something. Like it was bad. I have to look it up and send a picture.
There's Connor.
Did I read he got stung in the ear?
Said he got stung
Yeah,
directly in the ear.
that sounds terrible, man.
Yeah. Now Gingy's trying to hook up with him. I saw that in the chat, so I had to go get her a picture. Yeah. Look at her. Mm-hmm. Y'all leave Connor alone. He's a loner. He ain't got time for all that. Got rehab and shit. Leave him alone.
All right, what's up, guys? How are you? Oh, media scrum over here.
Hey, we gotta clear the ramp. We gotta clear the ramp. Let's go.
We gotta clear the ramp. All right, guys. So I just left the courthouse. As you guys can see there, the O'Keefe family and the other Commonwealth supporters are coming down the ramp. Bill Reed is being interviewed right now over there. And yeah, this is the bus stop live check-in. I didn't do this morning because honestly, I couldn't get a signal. And I got here a little late. Just pain in the ass getting here. I don't want to get Worcester. It's like not the funnest commute in the world, but save me. I stumbled into Twisted Tragedies and I'm not okay. Oh, that's a rabbit hole. There you go down there. That's a fun rabbit hole. Okay. Anyway, guys, I'm down here again. There's another great crowd here. I'm not going to go through it yet. I'll go through soon. It's just I don't like my broadcast getting interrupted. And, a lot of people ask for pictures, which I love doing. I just do it after the broadcast. You know what I mean? So anyway, we're going to do a little white boy power walk here. What's happening, guys? All right. So good morning, guys. Today is another day of jury deliberations. I predicted verdict today at 11. That's been my prediction for a while now. I don't know. What is there to talk about? A lot of people ask me, like, during the day, they'll ask me, how do you think they're doing? I have no insight whatsoever. None. No one has any insight at all. Actually, I believe they deliberate, like, right up in that room right there. I think that's where they deliberate from. Kind of hidden back. Like, no one could get there if they wanted to. I have no sources on the jury, and nor should I, or anything like that. We're going to walk down here. This is where Rogie Rogue was yesterday, spying on jurors. Like apparently he was coming back here and just sitting in a chair, spying on jurors. It was really creepy. But we're gonna take a walk through the streets of Dedham right now. Whew. How you doing, Tim? Anyway, yeah, I don't want to. There's like cops everywhere. It's like crazy down there. I don't want to get in trouble. Filming them something I'm not doing. Good. How are you? There's the Dedham Public Library. Yeah, you got the Christmas tree back. They took away the Christmas tree a couple years ago.
Like the Blair Witch
All right.
Project with Turtle.
So this is apparently where Rogie Rogue was sitting yesterday. So that, I guess that's probably the jury bus, I'm guessing. But he apparently was just sitting here, like in one of these chairs, which faces the courthouse. See that? And I guess he was just filming jurors. So that's really creepy. But and they say we're bad, but I thought they took a school bus, but they have like a nice coach bus here. Good for them. Today's the day, folks. I just have a great feeling about this afternoon. I don't know. Why not? Why not today? I mean, she obviously didn't do it. There's not much to talk about. But maybe they're just being respectful because this is a murder trial and whatever. Like, if they don't come back with a verdict today, that's when we get into hung jury land. I think we can have a more serious conversation. I think right now the odds of a hung jury are 10%. That's what I would put the hung jury percentage at right now. Normally, about 5% of juries hang. Since we've gone a day and a couple hours into deliberations with no verdict, I think those odds have increased to 10% plus the chance. Plus the the fact that this case is hung before, we've probably doubled it to 10% chance of mistrial or hung jury rather. Same shit. And with the verdict stuff too, it's like Jesus Christ, what a popsicle headache that is. So I don't know. I like what else? So I just think that they're gonna come back today. I think there's like a 90% percentage today that they come back and they acquit Karen. I just think we're in for something, And it's actually a really nice day. I thought it was supposed to rain. It's actually very comfortable out. It's probably like not too sunny, not sunny at all, really. Overcast, but comfortable out. Yeah, the deliberations took 27 hours. I posted my observations of what the jurors are wearing because a lot of people seem to think that like if the jury is well dressed that they're going to be on camera. I don't think that's how it works. I don't think anyone actually thinks like that. But I will notice that the women on the jury, 7 of them. They seem better dressed than they usually are. I'll just say that. The men are not, though. Juror 4 every day looks like he just got out of bed. Like, I'm sure he's a nice guy as long as he quits. But he's young looking, and he just looks like he just doesn't give a shit that much. Like, all 5 men I noticed are wearing sneakers today. The foreman wears, like, just a black T-shirt with a big-ass gold chain. He's like, I kind of love the foreman. The foreman is just wearing a big ass gold chain. He just doesn't give a shit. And I think he's the leader. I really do. I think he appears to be soft spoken and quiet. He's one of the older people in the room, which means he's going to command a little bit more respect. I just think that he's going to acquit. Morning. So yeah. What was that? Thank you very much. Oh, hello. How are you? What's going on? Today's the day. I can feel it. Yeah. So people are. I don't know. I just have a feeling, man. So we'll see what happens. My prediction today is acquittal by 11. Wouldn't that be historic? So, if you got nothing to do, you want to come on down, we'll be in Dedham. I know yesterday was disappointing because we didn't get the acquittal we were hoping for, but it's got to come sometime. It can't go on forever. And last year on the 3rd day deliberations is when they submitted a question, which was like the most action ever. So honestly, I'm hoping and I'm being idealistic, is that yesterday they kind of reached a consensus by the end of the day after reviewing all the evidence and the talking points they had all day. Imagine having nothing to do but talk about this case all day. Like the more you talk to yourself through this case, the more you're going to realize she's innocent and you have to acquit. And I'm just hoping that they said, why don't we just come back tomorrow, get a good night's sleep and see if we all feel the same way tomorrow. And if we do, then we quit because it's a really big decision and not a hasty one to make. If she actually did this, which she clearly didn't, that's your you would be letting somebody go. There would be no justice for John, But also, if she didn't do it and you convict her, that's also a terrible, terrible, terrible injustice. You're taking another person's life, essentially. So taking their liberty. So yeah, man, I don't know. I just feel it. I'm feeling not guilty. I'm feeling 11 o'clock. I just got a good feeling about it, man. I got a good feeling about it. So I'm going to head over towards the people now, but we will keep you guys posted. Obviously, not much goes on during jury deliberations, except a lot of speculation. A lot of people are going to ask me today, what do you think they're talking about? Spoiler alert. I have no idea. None. I'm just going to say, watch the bus stop live. I have no fucking clue what they're doing. So anyway, guys, I'm going to get going, but we will see you guys tonight for the live show either way. All right? Peace.
Because I know the arms broke. Two bones are right below the elbow. See how the arms are dangling now?
Depicting the damage to the liftgate taillight as well as the quarter panel taillight.
And what do you note in terms of that damage?
So on the liftgate taillight, a significant portion of that thick 5mm red outer lens is fractured and broken off. The underlying diffusers are still in place. There was a small crack in, I believe it was the upper diffuser here. The quarter panel taillight had the clear section damaged with the outer lens missing, along with some fragments from the outer portion of the red part of the lens.
Next slide, please. What are we looking at in this slide?
So this is another photograph depicting the quarter panel taillight. As I indicated, there is portions of the red lens cover missing. The interior diffusers remained largely intact in this test.
Next slide.
This is showing the result.
And Carmen knows your address.
Yes, we're 5 strong, powerful women, and you can't stop us. Look at that.
It's kind of lagging there. Hold on a second.
Listen, this is why people watch
Your channel, but life's a bitch, and so am I. And Carmen knows your address.
Yes, we're 5 strong, powerful women, and you can't stop us. Look at that. Listen, this is why people watch this trial and say, it's just off. Something is completely off with how they're doing this. And that's why many people think it's a national embarrassment. And there's so much, you just watch this and you can't look away, whether you are a trial watcher or a lawyer, whoever. You'll never see anything like this again. It's just so bizarre. There's so much mismanagement in just deliberations. Why?
Brennan's nasal polyp says, I just want to hear Bev say one last time after Karen is acquitted, Miss Reed, you are all set.
If it's a not guilty verdict, it's a choose your own adventure book. What is going on?
What, is it going to be like the last trial? And they're talking about that.
Right.
They know about it. It's impossible that they don't know, holy shit, this is happening again.
We are disgraced and we've opened our mouths and we have stood tall, okay? And those are things that there have been many of folk that have wanted us to shut up and not have our opinion.
Right.
And the reality is, if that influences them or certain jurors to make a decision.
Mary B, where are you at? You need to hurry up so you can get up here and tell us about today. Tell us about being down there and stuff.
One way or the other on the OUI, that's not justice at all. If that's what makes them vote not guilty or guilty on that count, just to avoid this, they ought to be voting on the evidence and the evidence only. And this has been twisted into a complete convoluted mess in the exact same way the first case was. And it's as if they learned nothing. It did nothing right after the first trial to correct it. And it comes back to one person. And she's sitting in the black robe.
Every American following this case right now should be infuriated with what they're seeing. Yeah. Every American following this case right now should be infuriated. This should not happen in the United States of America.
Which is not justice. A jury should never be thinking about, I'm afraid if I do this, this is what will happen. That's not an evidentiary fact-finding trip that they're supposed to be doing. And at this point, you don't know what the hell the jury is doing or why they're doing it. And you're officially in crazy town with this. You don't know what's going on. The jury doesn't understand. The lawyers don't understand. And the DA says, Judge, whatever you decide, I'm cool with. That's where we are.
Feeling positive about this jury. I like that foreman. Saw him with my own eyes. Okay. Saw him with my own eyes. He's a big man. He's a big man with dreadlocks and chains. We will stand up for justice.
Cool. I like those.
Results of the 29 mile per hour impact test to the test vehicle compared to that of the subject taillight.
Given that orientation of test D, were you able to reach any opinions or conclusions as to whether or not the damage to the subject taillight is consistent with striking an arm at 29 miles per hour?
It was inconsistent.
What's the basis for that opinion, Dr. Wolf?
The results of this test.
Was this strike more reflective of what you were attempting to replicate?
Yes, this was a more central impact to the arm.
So here we go with the super slow motion, 29 mile per hour hit. You can see the taillight's going to make contact with the arm. The arm's going to go flying. But as soon as it makes contact, right there, the elbow and forearm would have been broken and the arm goes flying. But look at the taillight pieces. They stay traveling with the vehicle. They are still going back at the same speed.
So this is a high speed or slow motion video depicting the test D at 29 miles per hour, just a different perspective than the previous video.
Okay.
Here's the same test at 29 miles per hour. The vehicle is going to make contact with the arm. The arm's going to get broken for sure, but it's going to also damage the liftgate taillight and the quarter panel taillight. But the arm in this test would have been severely damaged, well beyond what Buddy's arm was damaged, because that is a solid impact. Look how it bends. It would have bent the arm pretty much the wrong way for a human body. But it still didn't leave bite marks.
So this is extracted frames from the high-speed video. So starting out left to right, this is roughly at first contact with the majority of the hand, the majority of the forearm in contact with the liftgate taillight, with a portion of the elbow in contact with the quarter panel taillight.
Can I?
Depicting the sweatshirt or hoodie that Mr. John O'Keefe was wearing on the night of the alleged incident.
And what was the role that this played in your analysis ultimately?
Well, so one of the things that I noted, and I can go to the next slide, is there were a series of small punctures or holes in the sleeve, on the right sleeve of the sweatshirt in varying sizes. I think some as small as just a few millimeters. Again, I think there was maybe 10 or 12, I think I recall, on the right sleeve of that sweatshirt.
Can you count those for us, please?
On the photograph on the right, I believe I see a total of 9.
And what about the photograph on the left, just the right sleeve area?
9 as well.
If you look closely at the holes, they're all, except for one, in doubles. And the one that has 3 holes is on the elbow. And that's probably because he had his arm bent and was pulling his arm away, and the dog got another bite in. Neither my test or ARCA's test had any holes in the sweatshirt whatsoever. None. It's because the tail light cannot cut and put puncture holes in the sweatshirt. Just cannot happen.
What are the arrows pointing to in these photographs?
So this is basically the previous shot, but what appears to be close-ups of some of those evidence markers.
You indicated some of the sizes. What were some of the smaller sizes of those defects of holes?
From what I recall, like I said, I think it was around 3 to 5 millimeters, maybe some of the smaller ones.
How big is 3 millimeters in inches?
It'd be probably around like an eighth of an inch or so.
For all of us that live in snow country, knows when you drive your vehicle in the snow and the salt, what happens and what gets on the back of your car. I'll give you a little hint. It's little circles of dried salt, calcium chloride, salt brine. When you live in a snow climate, right before a storm, they coat the streets with salt. And then every time a snowplow goes through, they put even more salt on the road. And when you drive in snow, the wind that goes around your vehicle, underneath it and over it, it creates a vortice in the back of your vehicle. It's kind of like a vacuum cleaner. It sucks the snow up and it deposits the snow onto the back of your vehicle. I'm not talking just a little area. The snow actually coats the whole back of your car. Every nook and cranny gets salt in it, and water, and ice, snow. And when that stuff dries, it leaves those little circles of salt. Just like right here. Now, Karen's vehicle has salt spots all over it, all over the windows, all over the paint, all over everything. Look at the water spots. They're all over her car, except for the inside of the taillight. That is impossible. It cannot be that way. There's no way. Where are the water spots? There is no water spots at all inside of the taillight. That is impossible. Impossible. It cannot happen. There's only one way that is missing. The lens was on it in the Sally port.
Nice. Nice, Dean. I was waiting on Mary V to see if we could get her to get up here and tell us what the temperature was down there today. Like the atmospheric temperature, the vibe. But she's probably like at dinner or they're out doing some fun stuff. But we made our 3.5 hours. We got over 3 hours. We're good. So I guess it's time to bring this thing to an end, Dean. Dean is asleep. So when he wakes up, we will not be live anymore. We will not be live anymore after several minutes. But I appreciate y'all hanging out and not falling asleep. I'm glad everybody didn't fall asleep, you know. because it's happened before. Just like right now, Dean's asleep. Nothing I can do about it. So, OB is live, and Nurse Kim has Betero on there. So, a couple of good places to go. Good places to go hang out. Drop the channel. Get us in trouble. Screw it. No, not really. Do it if you feel like it. You don't have to drop in OB because she does it all the time. And I wish I could drop y'all in another room. That would be awesome. But it can't. And Mary B is not here to say, what time is it?
Puff, puff, pass. True crime chat rats. Let's go. Puff, puff, pass. True crime chat rats. All across the world, we coming through like that. Taking all the facts, put them in a trap. Cause we coming through like that. When you see the scene, I'm a rat. I'll be rolling with my rat pack. With my rats chatting about the crimes, the players and the evidence. Where it all went bad. Taking all the facts, and we bring them to the chat rats. True crime social where we be every night, doing everything we do for the truth. With my rats chatting about the crimes, the players and the evidence. Like it all went bad. Taking all the facts, and we bring them to the chat rats. All my people on the internet, all my people from around the world, gonna take you to the place we know best. Cause we're coming through like that. Puff, puff, pass, true crime chat rats. All across the world we coming through like that. Taking all the facts, put them in a trap. Cause we coming through like that. When you see the scene, I'm a rat. I be rolling with my rap pack. With my raps chatting about the crimes, the players and the evidence. Where it all went bad. Taking all the facts, and we bring them to the chat rats.